Yes.
Well, with your lordship, Steve, well, item 26 and 27, your lordship, will be taken up next week, madam.
Has not been called just 26, you said?
26 and 27, madam. I have informed the other side. Kindly have it next week, my lord, next Thursday.
Next week, if it's not possible, it goes in December.
Madam.
At the request of the council for the appellant, is this case on the 28th of December.
Item my lord, can it be a week before or after, my lord?
Anytime after, nothing before.
First week of January.
9th of January.
Obliged, madam.
Yes.
Item 23, with your lordship's kind permission. This matter was to have come up on 14th, your lordship. We had mentioned there was a joint mention made for this matter to be taken up on 14th.
Anybody is there on the petitioner side?
she had spoken to me last evening saying that despite our mention, it's come up on 9th.
This has to come up on 14th.
14th, Your Lordship.
23 at the joint request made by the council for the parties is this case on the 14th of November. Yes.
Obliged.
29, 40,
It is not yet admitted. It is not yet admitted, still on condone petition. It's admitted. Ms. Mamta, is it admitted? Item number 20.
It's not yet admitted, Your Lordship. I think delay was condoned, but it's still showing. But I'll anyway cross-check with the file.
The other side is taking praise for having it some other date. Any objection?
I'll leave it to Your Lordship.
29th of December. That day the senior would be overseas.
Lordship, on the next occasion, we'll, if they're not there also, we'll proceed.
Yes, yes.
Appearing item 30 and 31, Your Lordship.
Yes.
Requesting for these matters to be taken over 13 to 12, Your Lordship. Subject to Your Lordship's available.
Why 13?
Your Lordship,
Lucky.
we are being led by senior counsel in this matter, Your Lordship.
13 is lucky for you. 30 and 31. 30 and 31 at the request of the council for the petitioner is this case on the 13th of December.
Right. From 44 to 61. 47.
We informed the others that your lordship can be at this matter for 2 weeks.
We were there for the respondents.
Yes, Milord, 47. I don't have an objection.
47 at the request of the council for the appellant lead this case on the 10th of January. Yes.
Any date earlier?
23 appeal is state appeals of the department.
I leave to my lord. Because the issue is covered, that's the reason.
We'll take it up.
Very well.
Item number 32, the department is supposed to take attention to the reform protracted, but we need to find a counter.
32, Shri J.V. Prasad appearing for the department placed for time to file counter.
18 state litigation.
As prayed for this case on the 6th of February, the interim relief earlier granted to continue.
85 from 86 to 102, from 103 to 116, at 170 to 131, at 132 to 150, at 151 to 172, 173 to 177, at 178 to 199, at 200 to 256, 257 to 240. Item 1.
Yes, sir. You are for the appellant claimants or insurance company? Respondent claimants. 5th of December.
Wait, please, Your Lordship. There's a delay of 102 days in representing the appeal, Your Lordship. Connected appeal has been listed, posted to 23rd November for admission.
23rd.
23rd, Your Lordship. ITTA 139 of 2023.
ITTA
139 of 2023.
at the request of the council for the appellant.
Delay may be condoned, Your Lordship.
Number 1, which is an application for condonation of billing presentation. There is a delay of 122.
102 days, 102 days.
So 2 days of making the representation. Rest will be fair and due consideration and all that. Let this matter be listed on the so-and-so date along with ITTA number so-and-so for admission.
Obliged.
Item 2.
item number 2, Your Lordships, there are two questions which arise in this. Section 35(2)(a)(b) provides for weighted deduction in respect of R&D expenditure incurred on in-house research, Your Lordship. The question that is arising here is whether the weighted deduction would be available even if the expenditures incurred not in-house but outside. As is one case, the list of ITTAs at para 4.4, Your Lordship, which are already pending in the SSC's case at page 4.
Those are all admitted
Admitted, Your Lordship.
on the same issue.
Same issue. That is on 35(2)(a)(b). The second issue that is arising in this case is whether the corporate guarantee commission fee that is to be taken into account in transfer pricing, without going into, it has to be determined on a year-on-year basis and depending on the facts of the case. The tribunal has only followed its own order in another case, which is for a different assessment here. The appeals against that are also being preferred before Your Lordships. The one that has been followed by the tribunal also are being appealed against before Your Lordships. They're yet to come up. They're in the process of filing.
In frame 6.1 and 6.4, that should suffice.
6.3 also, because it's in violation of the rule.
6.1, 6.3.
6. In fact, Your Lordship, I'm sorry, even 6.2 would be relevant because there was a prescribed authority which has to approve the expenditure. So even if it is not approved by the prescribed authority, whether it would be...
Will it not be covered under 6.1?
So, 6.1 is weighted deduction, whether it's entitled for weighted deduction, Your Lordship.
And 6.2 also seems to be then allowing the weighted deduction under 35.
Because of the amendment to the rule, whether that amendment would be applicable to this particular year also.
Then why 6.3 then?
6.3 is with respect to transfer pricing. Rule 10B is on the commission issue, corporate guarantee issue.
Which also is there in 6.4.
Lordship, 6.3 maybe we can include it in 6.4. Lordship.
Transfer pricing is what is under challenge.
And regulations are there, yes.
6.1, 6.2 and 6.4. The appeal is admitted for hearing.
Yes.
Question of law.
Of immigration regarding the LOC. That's the past.
They are challenging the lookout circular issued by the income tax department, or in fact that it should be withdrawn. So whether it should go before a single bench, maybe because it was an income tax. In effect, they're challenging a lookout circular issued by the department. Lordship.
We will ask the registrar judicial to verify.
Tomorrow, because urgency, I'm leaving on 17th to Dubai for office meeting.
No, that would be, you will have to make a request to the registrar judicial for getting it. Because we don't know the position of the honorable bench which would have the roster. That been considered.
And they became aware of this lookout circular in September 2022.
No, the question is whether it will be seized by division bench or single bench.
let them make the representation.
For the petitioner submit that the matter has been one which has to be seized is to be heard by. Yes.
Like the score, it's the assessee's appeal. Now, the item 5 is the department's appeal. It's the very same order. The honorable CSAT stated 24th October 2007.
Yes.
But my grievance is a very limited one. The honorable CSAT dealt with two issues. Basically, one was on categories of services, basically renting services and advertisement services. They've given detailed findings on those. I have no grievance with those findings. The department who has come up in appeal in item number 5 against those two findings. Happened my lord, there was a third category of services, including mandap keeper services, where I had raised certain issues. For consideration of that in the input notice, all I am requesting my lord is for a remand back. And because they are also on the same page, because my lord, in their appeal, para 8.2, they also accept that the issue of mandap keeper was there. There is no decision on that. That is my limited grievance. The power at page 13. Because what happened, my lords, is it was a batch of 26 appeals decided together for all the municipalities. They followed an earlier batch order, wherein 30 appeals were decided. Because those batch matters largely pertain to these two services, the renting services and the advertisement services. Because it appears mandap keeper was not at all decided.
What happened to the other municipal corporations?
That they would be.
Because
Whether they were also agreed on the same order, because it appears that there was a batch matter which were decided.
all pertains to Andhra, it's Vijayawada, Visakhapatnam.
But whether it was subjective to challenge
I have no idea.
or for the department.
Yes, but I'll
for you.
have to get instructions. I will have to get it.
Suppose if there is some appeal preferred by the other municipal corporations, either before this court or before the Andhra Pradesh High Court, and if some decisions have been taken,
They must be again.
that event passing an order of remand may not be without dealing with that issue. I don't know what is.
Yeah, in my case, mandap keeper was involved. I do not know whether mandap keeper services were involved for other municipalities.
That's what exactly what I'm trying to ask is whether if the same issue was raised and it has been decided either by this court or by the other high court.
Then, can you have some question?
This I put the question last time also to you
No, no, it's
whether
last case.
there are other appeals also which have been preferred assailing the same order.
No, it's last station will be I took time for filing count. Then you have to say that it still is not admitted. There is no question of filing count. They have to mallet it.
No,
I anyhow mallet, I'll get instructions for that. Whether any appeals are department file any appeals against that orders before the Andhra High Court for that side.
You will be able to get it from the internet also.
And check. The amounts were small, my lords, because of monetary limits, I think they would not have filed. If they were mandatory parties.
Municipal corporation, rest of the all the parties involved in this and Andhra High Court. It is jurisdiction of the Andhra High Court.
No, true.
Yes. Earlier in can you get matter and somewhere. Monday, Tuesday and Wednesday, so that I'll be.
When do we have it?
It's Wednesday. By next week.
Week after next.
The week after next would be
Because except to 20
Next week, but
except 21st to 23rd.
after 20.
Any date after 23rd.
29.
Yes.
29 suits you. At the request of the council for the appellant Item number 6. Mr. Ramakrishna Reddy, you were requested to seek instructions on the last date of hearing.
Because the court is appointing me, but they are not giving any paper in the last, which have been saying. In yesterday's matter also, L&T matter also. The other day, he said he promised that he'll give the papers.
No, there was no representation on behalf of the appellant. Amity Srinivasu. And we were told that Mr. Falguna Rao
Yes.
is not, it was told that he was no more. In that context, we had asked you.
My name
Please
is
give
not-
it.
my name is not printed, but I have the paper.
You got
At least my name is not printed. No, sir,
I have an additional copy.
notice.
Additional copy. Just give it. Claimant's appeal for
My name is printed, but
injury case perhaps. Fourteen 8/12 is the accident. We'll have it at 2:30 also, no? Once when you are ready to offer your services, we can have it at 2:30. Only thing is, we will only allow you to argue in favor, only in favor of the appellant, not for the respondent side. That is condition precedent.
I'll go through now. Anyway, I'll ask the footnote to that extent I can say.
Yes, pass over.
They request you not to add this on. Okay. Like, here, but among the problems with not getting this.
At the request of Sri Devi Prasad, attorney for the appellant, raised this case on the 14th of November. The registry is directed to reflect the name of Sri Devi Prasad and the causes from the next date of hearing. Fourteen. What is the position?
So far as the selfie is concerned, we could not get the information.
I see that, we see that in opportunity.
Did anything transpire before the Supreme Court?
On the last occasion, let's say, as far as the respondent hearing is concerned, the dedicated offense was ended in acquittal. As far as the respondent is concerned. As against that, the appeal is also preferred with bank manager. That was also dismissed by the sample court in the month of July, where might be communicated in the month of end of August or maybe first week of September. Well, our information is that they are taking steps to bring the SLP for the script.
So that cannot be a ground for steps to be taken for filing or not even filed.
So far as special court judgment is concerned, basically, we have already preferred a criminal appeal before this one that's pending.
That's the difference altogether. What is there left in this?
Well, we are only just getting the information whether any if they are able to furnish me even the diary number also, that would be in place on record, and we'll take.
No, for the sake of saying that you have put filed an SLP and left it there, that would also not suffice. The order of the appellate tribunal. When do you want it? Not Tuesday, it will go on the week commencing 20th. By that time, you will be able to get some information. The request of the learned counsel for the. Unnecessarily,
Even the charge sheet is also by filed.
no, the matter is getting adjourned only on this ground for last couple of. Stage was the same.
First time I appeared, first time on last occasion.
No,
That's true. But there is no,
change in circumstances, the facts remain the same.
that's true.
Let us see, maybe on 23rd we'll be able to close it off.
Let's I vector represent minutes.
Yes, Mr. Sakhi.
Let's the matter is coming up for the counter of my learned friend. In fact, this is a case where the order is passed during the lockdown.
COVID order.
33 goes along with the UP number.
The first number order passed in 21349 of 2020. That was 21349 of 2020. WP number
21349
of 2020.
20
2020.
22
2020.
2020 decided on
12 2020.
2/12.
2020.
This is Biansky.
It's MS Ram, Justice Family, MS Ramchandra Rao, Justice TV.
Same order. Just change the
Oblige minutes.
fiction allowed.
Requesting respondent by filed Commissioner of Police. Out of 11 matters, in 8 matters we filed counter. 3 matters, the police officer engaged in election with only
That is now. He's not in election duty from 2021.
out of 11, 8 we filed counter.
I received today, Milord, my friend. This work, it won't take much time, Milord. Last occasion, I said, we are ready to pay during that period where the change is made. After that, Milord, it's a new product. Every week, Milord, they are changing the bill.
Our role is very limited, Milord. We only.
In that, they are granting the permission of country.
No, you say that out of 11, 8 you have filed, he has not even received one.
Today only, Milord. Today, 7 matters we filed yesterday evening, Milord. Today.
He has not been served a copy.
Milord, I will take,
Milord,
Milord.
let me explain. Sorry, but. Well, so we get 1 week time. Only 3 matters we have.
It is sufficient, Milord, even one counter. That's the point.
Answer is the same.
Same.
You just give him one.
Yes.
If you have an extra copy, you can just give him one. In fact, there was no need for you to file 11 itself. You could have simply passed an affidavit of adoption.
No, we don't have any role in matter.
Then we have to allow the petition.
He challenged the GST notice.
What about the respondents, other respondents?
The GST has filed the counter. And my grievance is this, Mirror. The
Who appears to them?
I'm appealing.
You are appealing?
TSHC, not this matter. TSHC is appealing. Today, his deputy marriage is there, whether he is out of station. Wasting some time and
So you have held back the filing of the reply.
yes,
When do we have?
2 weeks matter. If they file in counter to take different stand.
No, he's got it. He's just there's only one. There's no change in the counter.
it is sufficient, Mirror.
Yeah, Moses, it's the same in all the requisitions.
So there's no need for filing in all the 11.
I feel. 2 weeks matter. The state may take any different stand. There should be examination.
Follow the GOC.
Counter is there.
Yes.
With that, you have to make all your submissions. You have it on 20th, 21st,
Great day, Mirror.
20th of
I
November.
won't take much time. My point is only limited. Last time I expressed I am ready to pay the difference tax for the continuation of the film. Product will not 1 week. The next week will not, it comes to new product, they can't insist me. Their contention is existing product I am keeping because of reduction of GST, I am getting more profit. Here, every week is a new film, it is a new product.
No, but then your contention primarily was that
I was
It is not-
reducing it.
it is not within your control to either reduce or increase. It is
Yes,
unless you get an order from the government.
written permission.
That's it.
That's all only. The GST,
Question was, is it required?
they have.
Was it?
We only fix the maximum and minimum rate of the ticket.
I will clarify in 2 minutes. Any endorsement is to be made by the licensing authority, either reduce or enhance. That now they are saying. That is, rule position is there. Anything I want to change, even reduction of seats also, I have to get an order. Enhancement of rate also, I have to get an order. Reduction also, I have to get an order.
Your ticket price, how long has been constant now?
Now that the government issued GO 120, relaxing everything up to 350, they permitted, theatres are not going to reduce or enhance. This is more than sufficient, they granted government now.
Depends on the classification of the seats.
No, no, true. So what we were trying, what we know, no. What we want to know is like today it is at 250 rupees a ticket. This is within the limits of the government GO. Now, can he tomorrow raise it to 275 or 325?
No.
And mirror with the permission.
No, that's what I said. Can, of his own, can he raise it or reduce it?
No. Not permitting unless because we obtained court order.
No, you say that you are fixing a minimum,
Maximum.
minimum as well as maximum. So minimum is 150, maximum is
300.
300. As on date, it is 250 of his. Can he now enhance up till 340? Because it is within the permissible limits. Does he require a,
Yes, you can increase up to 300.
correct, does he require a permission for every increase? Even if it is for 5 rupees?
No, you can increase because as per the seat classification, you can increase up to 300.
Classification is different. Talking of, let us say the basic. Can he of his own enhance or reduce the
Yes,
price of that?
permission from the licensing authority.
Permission is required. So it was beyond his control. So then can he be taxed for that? If you have lowered the tax and you have not permitted him to reduce the price,
The state government has not reduced it. The
in
central,
the sense respondents.
yes.
Yes, here is that here it's the rate beyond the geo.
He had fixed-
for the tickets.
He had fixed the rate when the tax was at a higher level. Subsequently, the tax rate was reduced. So when the tax rate was reduced, was he permitted to reduce? Did he require a permission from you? Or did you instruct him to reduce in the light of the reduction in the tax rate? You in the sense either of the respondents. Whoever is supposed to do it.
That a batch of repetitions relating to enhancement and connection. Hello? Division bench has confirmed that I can produce that. Without permission, I can't do anything.
That is the only issue here now. Monday, next Monday. 20th. 20th.
Not to put it Tuesday. Any Tuesday, madam. This. Next Tuesday, 21st.
21st.
Yes.
Only on Tuesdays or any other day?
No, any day, madam, I'm ready. Monday, madam, what is happening? Various courts coming.
Then we'll have it on 23rd because 21st and 22nd we have otherwise fixed so many cases.
Madam, 20.
23rd.
Yes. Much of it.
20, 21. It is up till 21.
The other problem is arising, madam, in the same cases. The commission is now transferred to competitive commission. They are insisting every theatre owner to appear in person, madam. Every small theatre has to go to Delhi. Today, madam, they posted 2 matters. You made a request to grant permission for online. They refused. In one of these cases, the Supreme Court says, why everybody is wanted to appear personally in Delhi? Now we are facing that problem also. Once it is over, the entire state will be free theatre.
Yes. Yes.
Under this restriction, challenges with transfer to file from Mumbai to Chennai. I informed the department that the company registered operation in Hyderabad. All operations are in Hyderabad. And they have nothing to do with Chennai. There is no purpose of transferring the file in Chennai. They requested instantly file will be transferred to Hyderabad. Well, since it was not done, I find that this restriction is also an interim order. Interim order is dated
20th of April.
28th of April.
Yes.
Well, I very, in fact, I kept up the position as to presently what is the position. I understand, my lord, that the orders are issued, transferring the file to Hyderabad. And
That has been done.
yes, that's. I understand the orders have been issued. The file is moved to Hyderabad. I don't have a copy of the order.
The grievance stands redressed.
My lord.
So nothing survives.
If that is so, that is survives.
We'll take your submission and we close it with the permission to revive in the event if anything remains. The instant repetition was filed seeking
Application, your lordship, is to direct me to serve copies on physical and personal activities.
Is he there? He was here, I think, in the morning.
The
I think he was here. I saw him somewhere this morning.
petition was there.
You have served a copy to him?
Yes, sir. On 7
So Shashi Kiran, are you connected online? We'll just pass it over if you can just speak to him.
Yes.
Pass it. How much is that delay?
For 997 days, not in the presentation.
900
Yes, 977 days.
3 years. Better appetite file.
Yes, sir.
When was that file?
1310.
When?
Stock to reflect total 131020.
It's not there. What we have is dated 25th November 2020. That's the original.
The request will not.
You have the US, you have the USR number?
The USR number I do not have. Not me until 14. I not prepare unless I put it in the file. That's not the problem.
The request of the council was approved to make available the better affidavit that has been filed explaining the delay in making the representation. USR number is given in the cause list. What of it?
Better I find another set plot.
Why are these matters not like 13th of October is almost 1 month.
Filing section and this section, they're not sending us time. I'll put it.
This is not the first one. Every day there will be 1 or 2 matters. The filing is not long back, but the matters documents are not attached to the file. Who's in charge of the filing section? Who?
50 is there.
Who is it? What is the
Section officer.
section of the
Yes.
college? We have it on 15th. 15th you are there. 15th of the request of the council. We have this case on 15th of November. The registry to take steps and ensuring that the better affidavit filed on 1310 is back to the file.
Let me file this. That's that. But the substantial question is, I said, my lord,
Not sure you'll find that at page
8.
yes. Page 8 manner. Whether on the facts and circumstance of the case, the sum of 18 lakhs paid by the appellant to Udyaman Private Limited for giving up all its rights and for cancelling the agreement dated 14/3/2002 entered into by the appellant with it is an allowable deduction fitting the same to the expenditure in connection with the or in the alternate cost of improvement following either under section 48(1) or 2 of the IT Act while completing the application the sale of property at value in hands of the appellant. Whether the facts and circumstances of the case, finding of the judgment of any is not connected. No, that is not the finding actually. There is such finding. Question number 2 may not be relevant. But when I shortly briefly to state, the SSC had some property in Bangalore. Now, initially agreed the agreement for the purpose of development of the property. Then later he found that the person with whom entered into the agreement did not have the wherewithal infrastructure to carry out the construction. So he wanted to change the builder. And the agreement holder was unwilling to change the builder and he insisted he would wait. Finally, a compromise was arrived and a sum of 70 lakhs and odd was paid. Out of which 18 lakhs pertains to the land sold in this year. I claimed it as a deduction, treating as a part of expenditure connected to the transfer or in the alternate cost of the asset, in addition to the cost of the asset. Well, this was denied. And the same question came up for assessment year 2004-5. It was decided against me. I filed an appeal ITA. It is number 465 of 2010. Same question for the earlier year, 2004-5. The ITCA number is 465 of 2010. That is admitted.
But if you look at paragraph 3 of the impugned order passed by the tribunal, they have given a reasoning.
Tribunal's order.
Yes.
Page 22. We note from the producer of the case record as well as in the light of the alleged assessing officer's commercial assessment order that there is a second round of proceedings between the parties in furtherance of the tribunal's first round of main order dated 18/12/2009 on record. Well, this 18/12/2009 on record as a pertains to assessment year 4-5. And you look at page 26, Mela. Not will find 1364 of 2008 relates to assessment year 2004-5. And in the realm of income tax law, every year is separate. Regardless of what happened in the earlier years, I might allocate for it in the next year or I may give it up. So my respective submission is 2004-5 the matter is pending. Same questions, same parties, similar thing. The reason is like
That stands admitted.
pardon me,
That has been admitted.
that is admitted. That my endorsement is admitted.
And what is the finding in the later part of that same paragraph? It emerges from the refusal thereof that the
The issue has been raised in the SSJ syndrome 11 to 15. The state appeal stated 1364, that is for the previous year. What is happening now? The order was passed on this point against me. There were other grounds which were tribunal omitted to consider. Other grounds relating to other aspects, not on this issue. So we filed a mysterious petition to recall the order in relation to those points which we had not adjudicated. We passed the order adjudicated. So
that was allowed.
but
Your MA was allowed.
no. Tribunal might not accept this. The matter was then this miscellaneous question was put.
No, if you read the last line of that same paragraph,
And
it said 6 grounds stood restored back.
gave up fresh adjudication by Dr. dated 22/11/2011.
This must be in your MA 22/11/2021.
2011, it was restored for assessment year 2004-5. Not 6.
You tag it up along with 465. Let the appeal be listed for hearing on the
Lord, I'm discussing the concept of issue. That means the retirement should. You know, when you order this matter, item number 30 here. By scenario of convenience is not able to appear for it. Only request to post it next week.
he is busy with a heavier file.
The counter has been not.
Counter has been filed.
How does been fine? But instead of next week, not may have it in December. Also,
Actually, this emergency.
Emergency is there, but your senior is not there.
next week there are a lot of number of factors that are coming up. Man,
He is not there from next week. Up till 12th of December. We can have it on 14th. You, in any case, you have an interim protection. That would stand continue. 14th or 15th, 14th. 15th is Friday. 14th. The request of the council for the petitioner is this case on the 14th of December. It will be earlier granted to continue. Who's for the appellant? How much is the delay? Mr. Ramakrishna Reddy. No, we last time we had asked you to enter appearance under instructions of Harinath Reddy.
yes. Said he was unwell last week, but he said he was. Because in Amaravati, my first Mr. Bishop, I could not. Today, he may be there, last occasion. Was requested.
No, last occasion I think you had entered appearance there.
Please request me, I made it. He requested me to take time.
For today.
For today. Yes, fully kicked off.
Let's say delay of 24 days.
That we will allow. What is there on merits? What is there on merits?
Cancellation of the total expense Miller. The salary was fixed.
and compensation was awarded after deducting 1/3 and 10% addition of future prospects. He was employed singularly in campus.
Yes, madam, what is there?
But next week,
This is what you said last time also when it was listed. We had given you the date today.
they said the funding.
We'll have it second half, go through it, we'll permit you ask for, take it. If there is anything, we will admit. If there is nothing, why we keep it pending?
Years together, it will go.
Second half, 2:30. You can have a file, you can take the file of your friend. No, you should not interfere in between. Where is he? Yes, what happened? No, this is not the first time that we are facing this. Every day there are so many matters coming up. 1 month, does it take the file IAS to be listed along with the file? Things are not moving correctly or rightly there.
Six bench and 1%.
Lockdown. If you are not able to do, explain your problem to the registrar general. That doesn't mean that 1 month things should not be moved.
From 36 and 37. Because the
Yes, which is. Who's for the petitioner? Item number 36. This is that case where the counsel appears from the Supreme Court?
Yes, sir.
This was heard by.
Previous that, so this bench needs to hear it afresh or not, again needs to argue for admission.
When it would go on. It would be better if you give it in list it on a particular day on which all those tied up matters can be taken up together. Well, we are burdened considerably so far as the entire show cause is concerned. Well, kept in abeyance on an assurance given by the council. There was an undertaking given by the council, there was no such interim as such by the court. The council had given an undertaking that meanwhile they will not take any precipitative steps.
Last year, because of this non-appearance, that is, allowed to.
No, true. The instant matter was one. She comes from outside. Yes.
That's looks like my friend is not there.
Short password is very good.
Password.
Plus, instead of password, let's have it tomorrow. Minutes.
Tomorrow is not possible. Next week also.
Yeah, it can be disposed of. That's the reason. No, it's a short issue.
We'll have it at
It'll take more than 5 minutes. Certainly more than 5, not more than 5 minutes.
2:30 for you.
Plus 2:30, I have a parted in another bench. That's the reason today.
After that 2:30, we have already fixed a couple of matters. After that, by that time, your partner would be free over there.
Only request tomorrow, minutes. Or Tuesday is also okay with me.
Should be okay for us also. There's no question. We don't have any difficulty in fixing the matter on Tuesday or Wednesday, but the question is the cause list would get heavily burdened. You can start.
Very well, minutes. This is a matter arising under the Finance Act 1994, minutes. The petition before my lords is an advocate. This is a matter where service tax has been levied on the advocate for the services rendered by him in his professional capacity.
I will charge service tax.
Previous matters under the caption of 230. Two matters. That's why none appears in the petition.
Somebody is coming from the petition?
Yeah, Supreme Court advocate is coming.
No, it was heard at length by the.
I'm afraid, because it is not under part of the lordships may have to hear it again. I called the council yesterday. He said he's already come. Therefore, he's not seeking it.
So we will release it from Partha, then we'll hear it all together again.
Yes.
cancel it, keep it placed faster.
The 230 caption.
Yes. The 230 caption was for 1910 when it didn't materialize. Therefore, it was simply exert.
Yes, yes.
Just post Puja holidays. Because of time constraint, it was not taken up, and you had instructed them not to come.
Because it's still showing as 230, the council did not appear, maybe because yesterday when I spoke, he said that 230 captions, the senior will come. Okay, Mr. Please.
Yes.
My lords, this is a matter arising under the Finance Act 1994. Petition before my lords is an advocate. This is the case where service tax was levied on the advocate for the professional services rendered by him. My lords, as your lordships are aware, my lords, in terms of notifications 12 of 17 and 13 of 17 under GST, as well as 25 of 12 and 30 of 12 under the service tax regime, advocates are exempt from payment of service tax, and the service receiver, if it is a company, is liable to pay under the reverse charge. Lordship, may kindly have a look at the order for a minute, Lords, at page 22. Lords, the fact remains in this case is that the notices were not served on me, but he has the entire information. He got the entire information from the income tax department. Lordship, may kindly have a look at the order at page 22. It starts, my lords. At more than three or four places, he refers to the information received from the income tax department. Because at page 23, just above the tabular column, my lords, fourth line. It was ascertained during the period for the financial year. Lordships got it, my lords?
Yes.
15-16, the SSC had declared an amount of rupees 35 lakhs 50,000 so and so in the income tax returns as gross income to the income tax department. Its service tax liability on the said amount works as under. Plus, that is one place. Again, at page 24, my lords, just above para 3, last 3 lines. In the absence of any documentary proof, basing on the data given by the income tax department. Likewise, my lords, at page 25 also, paragraph 7. As seen from the data forwarded by the income tax department, the SC declared a service in the service, declared their service income in the ITR under the Income Tax Act as so and so for the financial year so and so. Relying upon the income tax data, which is reliable information, the department has proved beyond doubt that the SSC has provided services and received consideration for the same from the recipients. Now, my lords, the data what they have received from the income tax department, Lordship may kindly have a look at page 28. That is my income tax return, followed by the audit report. It starts at page 31. And Lordship may kindly turn to page 39, my lords, part of the audit report. Item 10, the first line, my lords, details of business or profession. It says legal profession. And then page 40, my lords, the first line again, total turnover of the SC. 35 lakhs 50,560. Because this is the information they have received from the income tax department. Lords, noting all this, in fact, the Lordship may have a look at the interim order passed by our Honorable Court on 23rd of March 2023, my lords. After noting this, my lords, this is the interim order passed. Third, so and so, Lordship got it, my lords. The third paragraph, challenge made in this writ petition is to the order in original dated so and so passed by the respondent number 1, confirming levy of service tax on the petitioner for an amount of so and so for the period so and so under Section 73(1) of the Finance Act 1994, besides levy of interest and imposition of penalty. It is submitted that the petitioner is an advocate by profession. Central government has issued several exemption notifications whereby services provided by an individual as an advocate or as a partnership firm of advocates by way of legal services are exempt from the charge of service tax. That apart, there is a provision for recovering service tax from the service recipient. Ignoring the above, the impugned order in original has been issued mechanically.
What do you say, Mr. Dhoni? Why?
We have no proof that the notice has been served to him.
No, once when the category stands exempted, how would they have proceeded?
They go purely by the income tax return.
No, true, but then they are themselves have perused their income tax records and found that the profession is a legal profession, which is one of the categories which stands exempt.
Leave it to your lordship. Hence return to sender.
So it is not answered. No proof of proper service. That is what we say.
Yes. See that was the registered address.
Further,
Obliged, my lords.
the students will respond to the questions.
और अभी तुम्हारे लिए करते हैं
None appears for the petitioner when the matter is taken up for hearing. This is case for hearing, further hearing in the 18th of December.
40 and 41. What are the legal
No, 40 is penalty after. Last edition, the last verify the record. My contention is the order passed by the first respondent did not show the penalty order till today. Is not uploaded in the portal also. Then we file appeal for the appeal. That's recently the circular issued Central Board of Indirect and Customs. Circular.
Wording? You were also forwarding the same thing?
No. And the third point before this question was posed and I appeared last time, but I was not before. So my instructions were that he said that his order in original of 2019 was not served. But that we have proof to show that it is served. Therefore, everything that follows is emanating from this order in original. Which
we take up that first.
Yes, 41.
41 first.
Yes.
By the way, what is this notification?
The notification is even prior to 31st March 2023, we have preferred appeal up to January 24th. They are controlling the delay and settlement. But instead of that, paying the 10% of disputed amount, so they are collecting 12.5%. The condition is there.
You don't have any difficulty in paying 10%. If it is 10%, you are ready to pay.
Yes, sir. But the order originally is 2019. Let them serve the appeal. I'm having for appeal of it having been served. I go for appeal. I'm not practicing any. The whole purpose of the rate.
Give us 41 first. 41.
41 is yours.
Challenge is to the order in original dated 25/9/2019. 41. Item number 41.
Yes, sir. I have passed on the proof of having.
Pass it on to the other side first. Who was disputing?
Yeah, endeavor will be to remand it back so that he can now prefer it or revert the books. For saying not served now.
What is this now?
Now, this is an email to the petitioner way back in 2019, which has the order.
Yes, Mahashetty.
@gmail.com.
The petitioner's father. Is only sent by email or any other mode also?
Well, in fact, PH was held on 29, 2019, which was attended by Sri Ramesh, the same person, managing partner of Messrs. Darshan Cotton Industries. So PH was held and he attended also.
When?
On 23/9/2019.
Where are you getting this from?
And that's not in the writ petition, but my instructions are that paragraph 9
Of
the order in original, page 22. We had an opportunity, and there subsequently the penalty. Now the next case is where due to his late payment of penalty, his registration was suspended. Against that, he has to now the show cause notice has been
no, that also is that of March 2023.
Yes,
What is it still under suspension or final orders have also been passed?
it is under suspension.
Yes, how do you explain this?
There's no signature of my is the only problem. But they can take out
That's been sent to an email.
no, not email. I repeated in second repetition. I filed email one. That's a suspension order. So I filed that.
Yes.
If it is there, I will file it. If it is not there, this will be coming here. The penalty order is not uploaded. Till now.
Not the order. The order in original.
Not yes, that is fact. Not
It has not been uploaded. Normally,
invariably they get uploaded as well. What I said. Email is sent to him, will not be denied. This is not his email address already. Same person appears for personal hearing. Email is sent to
you had entered appearance on personal hearing on 23/9/2019. You have made your representations effectively before the authorities concerned. And it is only thereafter this 25/9, that is after 2 days, the order was passed. It was uploaded, it was immediately sent on your email on the same day. What is there to disbelieve this? What is there to disbelieve?
That's we verify my portal, we open it. It is not there, Your Worship.
Email.
Email also not there, Your Worship. Suspension order put on email only. Suspension order is very much there, Your Worship. I find the email also.
That is only when you woke up.
Yes, sir.
When the order of suspension was passed,
Yes, yes.
immediately Vocam and started filing all these.
Degree of that, I filed a representation before they.
Then you were not really aggrieved of the order of.
I filed a representation to revoke my suspension order. And he issued notice again, demand notice to me.
Yes, why would he not do that? The demand notice is different, the suspension of your registration is entirely different.
Yes, sir.
So this we will find it difficult to entertain. After so long, 2019, writ petition being filed after.
That's no problem. Till today, circular is given, the circular is entertained my appeal. In view of the circular, so I'll go and file appeal. No doubt about that.
Then you go and avail the
Let me
remedy.
serve the copy original.
You have it with you in the writ petition. You can file.
This order I collected, so I stated in my parent, writ affidavit, this order collected to my bank.
You have a copy with you. Take steps.
But without original, they won't entertain also. Even though the circuit will file online only also.
You can, there is a mechanism for getting certified copies.
We can again give him a copy. There is
No, there must be a.
Online portal also can be taken.
Online,
We will, not in any stage, your lordships have passed orders, not saying that liberty to file out. This order as well as an order from the court. However, that liberty not 2019 case is limitation also is.
We would not.
already granted by circular limitation. I don't, there is no dispute. Limitation. Till today, I'll file appeal up to January 2024. They have given.
If he has the limitation still available with him, nothing prevents, he can approach the authorities for a certified copy.
Very well.
41. The challenge in the present writ petition is to the order in original passed by the first respondent. 25/9/2020. Holding the petitioner liable to pay. The GST and SGST. Where would he get?
We will give him a certified copy, but that copy will have a stamp of a date today, and he will take that from the limitation.
We will mention that in our order, that we have already clarified. He says that even if he gets a copy today, in terms of that circular, he still has the limitation for filing the appeal.
If it is, the Lakshmi say,
The government is senior standing counsel.
not to take in first.
And
Have they taken anything?
what they have done is that next case, the suspension. Second party, it's not-
Yeah.
it will become infraction. But when he says the state, saying 12%.
In the light of the disposal of the other matter, we will dispose this,
Yes.
reserving you right to take appropriate steps before the department.
Shukla procedure, I can't run the appeal.
We just wanted to know, would you have suspended him at the first
Same
instance?
day, with effect same day.
To give an effective appellate period, yes, we could have suspended.
When?
But now we are coming to recover.
Which provision says suspension?
Right now, right now, it's under 29 2A. Madam. Of
The show cause.
Yes, now the suspension. Section 29 2A. Yes. The GST Act. His account has been suspended and show cause notice issued because he failed to pay the penalty imposed on them in contravention of the provision of the order and original dated 25/9/2019. So it is the same order which your lordship has now granted in the going on. Now, petitioner takes his steps now against the reviewed order, which in the Section 41. He pays the appeal amount. Then automatically all the proceedings that follow from that order, because this is emanating from non-payment.
Non-payment of the penalty.
So this petition is infractious in my view.
Infractions only after he prefers an appeal.
Yes. Now it is for him not to move. He can do it within 10 days.
Dispose it of.
Payment of the highest will pay. But directly revoke the suspension on it, because the autumn season is started. That's the difference to me.
How can we do that? In the teeth of the order of original lying there.
This is 23 also. Suspension order is 23. March 23.
Correct. This is an outcome of the non-compliance of that order. That you would be preferring an appeal.
Different.
Upon your preferring an appeal and paying that
10%.
10%,
Yes.
the consequential order automatically loses its efficacy. There will be no further need.
Without direction, they can't do anything else. My friend will say here, but department people is something different. We are facing a lot of problems.
Let them say. Let them say. It will be to your benefit in any case. You will get another round of fees.
Yes, observe that order it may put in this order.
The challenge in the present book petition is to the show cause notice.
You are seeking a pass off on file with the car.
File?
Yes, the hospital has to be.
First, you would have asked the council not to wait.
No, I told him in the morning, it was 9 o'clock, I spoke to the officer.
It's on the file now.
No, I need to take it, still request and take it to the.
1 o'clock I have to take.
2:30?
If the other matters are there, nothing.
Those are small matters, though, not, no final hearing matters.
Anyway,
Right.
Forty-three is the insurance notice appeal. 44 is the claimant's appeal.
You are appearing 43.
Yes, for 43 I am the appellant, but 44 I am the respondent.
43 is insurance appeal.
Yes, ma'am. But 44 is filed with the control delay, the delay of almost 359 days. But anyway, as it is being disposed of with this mode,
Death case,
it's a death case.
delay may not be an issue.
That's what I'm saying, but because this matter is there, then consequently an order can be passed after hearing this matter.
Yes, yes. Anybody appears for the claimants?
But the name is Mr. Kerala Pro was appearing, he is no more. Morning only advocate came and told me that he is going to appear.
He is appearing?
And the advocate informed me that he is going to appear.
He is going to appear?
Yes.
Who's there? Who?
Makam Ishwar.
Come Ishwar, yes, his name is there.
And he was in the court also.
Anyway, you start by maybe by next time we can join.
Yes, ma'am. No, this is
You are challenging the liability of quantum.
no, it will be both, my lord, because it's a case under section 166 of the Motor Vehicle Act. OP. But the policy was issued as only a liability policy, that is act policy. That is one aspect. The second aspect, the disease was driving the motorcycle. He went and rammed into the alleged crime vehicle. That is brought on the record. That is not considered. Lord will see the material records in here. But the OP was filed.
Meanwhile, one of the respondents have also expired.
Yes. That will be not an issue, Lord, because that's only a road driver. So except it's a owner.
Not one of the claimants.
Not claimants. But according to the case, the disease was proceeding on his motorcycle bearing number so and so from Hyderabad to some village, according to the claim petition. Then they say that the crime vehicle lorry came from backside, driven by its driver in a rash and negligent manner with high speed and without following the traffic rules, and damaged the deceased motorcycle, resulting in the deceased receiving serious bleeding injuries while shifting to Kamineni Hospital. He died and his friend also received multiple bleeding injuries. So therefore, the case set up by them was that the person was going on a motorcycle, there was a villain rider for that particular vehicle, and the lorry vehicle came and rammed into them from the backside. But when they say that, they have to prove it under 166. The counter was filed, policy is filed, then evidence also is letting. But the PW1, that is the wife, he also reiterates the same story as set up in the claim petition. But I'll be very short, minute. They only marked 5 documents and then subsequently we cross-examine them. PW1 says she is not an eyewitness. But I leave it to that particular thing because I'm going on the liability basis. Then PW2 was examined. But PW2 is a villain rider who says I was proceeding along with this particular person. The cross-examination of the person is very important. He says the disease was riding the motorcycle at the time of the accident. The accident took place on the national highway. There was no divider onto the said road. I was a pillion rider to the of the above said by motorcycle.
at the time of accident. Police did not inquire me about the said accident. Witness adds that as I have also sustained injuries, they could not examine me, inquire me. I have studied up to 10th class. Police recorded my statement. This is important. Police recorded my statement sometime after the accident. It is true that I am seeing an accident. Myself and the deceased chased the vehicle involved in the accident. And during the said process, the accident in this petition is occurred. So what happened is, if the officer is considered alert, these particular persons were going on a motorcycle. They saw an accident happening. They chased to catch hold of that person who caused the accident. In the process, he went and rammed into the vehicle which was standing. That is the story. Coming under 166, but then they have to prove the accident. It is none other than the PW2 examined by the petitioner, who was a fill and right. So it is not any outside. Then the PW3, this PW3, I'll keep it aside for a minute first. This is regarding the employer. Then I examined RW1. RW1 stated the fact on the basis of investigation. But we'll keep that aside because it is eyewitness. PW2, RW2 is the person who has filed the charge sheet before the court. That is a SI. But we confronted with him the document also. There is a statement made by the witness. So I just read the short cross examination, chief examination and cross. Presently, I am working as SI of police, Chandan Nagar. Previously, I worked as an SI of police in Achapan police from 2006 to 2008. I registered claim number 94 of 2007 on 16/10/2007. I filed charge. It is true that I recorded the exhibit B2 statement. As per exhibit B2, the alleged accident was occurred when the deceased and one Narsimha were chasing a motorcycle who caused another accident and dashed to a lorry. After the accident, we itself sent the injured person to the hospital in 108 ambulance. Exhibit B3 MLC, the injured is said to have informed the hospital authority the accident took place due to the motorcycle colliding in the station the station lorry. So therefore, it is now clear. The person driving the motorcycle, his legal heads are the petitioners here. They come under 166. They have to prove the negligence. Their own witnesses and the inspector, the person who has filed the charge sheet, owns their particular case. That means that the insurance company has made out a case for the purpose of saying that there is no liability on the insurance company and the legal heirs of the deceased cannot take advantage of his own negligence. That is beyond doubt. That is the aspect relating to the thing. Not the confrontation process and everything is there. Then, as regards the income, they set up a PW3 who comes and says that this particular person was working in the college as a senior physics lecturer and he was drawing a salary of 10,200 per month, basic 8,200, HRA 1,000, NTA 1,000. Now the scrap of paper relating to acquaintance register, attendance register, education qualification is there. Anything can be created. Let us take it, without even we leave aside the proofs. There is something which has to be given to 4,500 or 5,000 rupees, whatever what's considered. That also has to reduce the compensation. The court has taken 10,000 and then come to an arrival of around 14 lakhs, which is the compensation. PW3 is the employer, the alleged employer of the person who has not brought any registers, he has not brought any attendance register, he has no qualification certificates, nothing.
What is there to disbelieve in?
But if my lord says that what is there to disbelieve in, the cross-examination itself will say we have to disbelieve him for the reason that he was not able to prove the basic document of an attendance register or that he was working in that particular organization and earning so much money, income tax returns. Then he says it was not paid in account also, it was paid in cash. He says that it was being written in the acquaintance register that the amount has been received. This is what is to be taken as proof, there is nothing else. This is the evidence of record. It is 161 statement of PW2 was also examined as B3, exhibit B2. This was confronted by R2. He has admitted that particular statement. They themselves admit that they were on the motorcycle and they dashed it. Therefore, the question is this who was driving the motorcycle in a rash and negligent manner, racing to catch hold of another vehicle, which had caused an accident. He himself went and landed up in the accident.
Is the conclusion needed to?
So the court, very cryptically, was everything has been done, but page number 13, they will look into material papers. From the evidence of freedom, paragraph number 9. I'll just read the little about page number 30, internal page 5, around 6 lines. In the cross-exam, he admitted that place where the accident took place was a national highway and there was a road divider. He admitted that on seeing an accident, himself and the deceased tried to chase the vehicle involved in the accident, and in that process, the present accident took place. Paragraph number 9. In the evidence of PW2, though it is contended that accident took place when the deceased himself were in the process of chasing another vehicle, but the assertion made by the PW2 is that there was no negligence on the part of the deceased in the process of chasing another vehicle. I'm not saying that there was no chase. You can do whatever you want. But you go and land up in an accident and you say that particular person is liable to pay the compensation under 166.
Where is that evidence to show that there was a negligence on their part? You are only trying to say that but then it says that the accident occurred because the deceased and the pillion rider in the course of chasing another vehicle.
Yeah, chasing means
with an accident does not mean that there was negligence on their part.
When a person sees an accident,
Correct.
he starts chasing a vehicle that will not be in a normal speed because that particular vehicle was not standard or columned on, it was going.
Yes, let us say that he was at high speed, but then can that be a negligence?
His mallet, he goes and dives into a standard vehicle.
Where is that evidence is missing?
But is what is the admission? It has to be read between the lines for a day. Nothing will come on record like that.
It's a welfare legislation.
But it's a welfare legislation not against the insurance company. We are not leading, but we are paying 14 lakh rupees. Is there? What happens is when a person who is driving the vehicle and it is a known diagnosis. He may have an own vehicle 15 lakh policy or something. He could take that amount. But not come and say that there was a rational negligence driving the opposite vehicle to 166. That's what I'm trying.
There's no evidence other than the inference that you are trying to draw from the statement of the another injured.
Well, the person says
that person says that had they not chased, the accident would not have occurred.
Yes, sir. I would have not been here also in this case. We would not have been addressing this case.
We would have also been less of two cases.
There is one case here. There were two cases.
Two cases.
But what happens is like this. But you come and file a petition under 166. You have to prove the case. I disprove the case. You come and say, and that's why I did not even talk about PW1 because she said I have not seen the act. PW2 is none other than the person sitting in the back. He also suffered injuries. But if he was not rational negligent, he had not done anything, he would have chased. The other person sitting back would not have got injured. Immediately, he was also sent to the hospital. Means how much rashness it was there that they went and rammed into the vehicle. Please.
It's not presuming too much.
But it's not the question of presuming. I'm trying to submit that reciprocal locator is there, evidence is there, police evidence is there. Police also says, but the three angles there. Melot will see page number 14 in the middle. How about three different versions were created by them? One, they say that according to PW1, the disease was proceeding on a motorcycle. The lorry is said to have come from Spain and dashed the motorcycle due to which the accident took place. That is one version.
The normal case when a claimant files an application that he will cover. Yes.
Second aspect, exhibit B3, when the person goes to the medical, there are PW2 went to the hospital, he gave a statement in B3, which is a medical legal record issued by Kamini Hospital. The history of the case is recorded as alleged to have sustained injuries when the vehicle on which the injured were traveling collided with the station vehicle. So therefore, there itself it goes wrong. Third version, as per 161 statement record.
It was a national highway. And if the offending vehicle had parked it negligently without following it.
I would have appreciated if there was a line in the pleading saying that the vehicle was kept in a wrong place.
Who is going to say all these things, particularly in a death case?
My lord, I have to only say that, my lord, I have done my job as an advocate in the insurance company.
Where is
Lieutenant Khan was the counsel appearing in the lower court. My lord is assisting and taking the.
put all the blame on him. Put all the blame.
Telling him the same thing that you have done a good job. Now I find that I have to tell you that it was no good job. So, my lord,
Where were your surveyors? You could have got it surveyed. You could have got the surveyor examined.
no, my lord, that's what I'll say. The RW once came on the basis of the survey report, that investigative report. He said what happened. I have not read the thing, but he said that this is what is the report given by the thing. To reiterate it and to prove it, my lord, we brought RW to that inspector also to file the charge sheet. We got marked the exhibit B2 and B3.
W2 is only the inspector who has filed the charge sheet.
Well, we have filed the charge sheet.
Except for materials that were available with him in the file.
But he did not say that. He did not say that.
Charge sheet is against the law or?
It is a law. But just because of the mistake of a person, because person would have, if a person would have died, if it is mentioned that it was his mistake, it would have abated. There is no case. 163 that would have come. Even then, if my lord has to say that the vehicle was kept in a wrong place, it was kept in a place where it was not supposed to be kept. It was not kept with a red light, it was not kept with a cloth, it was not kept with a triangle. All these things he will give us benefit of doubt also. But what I am trying to say is, there is no case like that. I can't answer to a case which is not there in the pleadings from the day one to day end. So therefore, my lord,
You are trying to put up a case where an inference to be drawn, reading between the lines.
Basing on exhibit 3 statement.
but between the lines is for the question my lord asked me. That is, where is the proof that there was negligence or no negligence?
Exactly.
But no, anyone comes, my lord, in the cross-examination, we have to disprove the story set up by them. What is cross-examination? I cannot ask more than that. It's a summary procedure. Courts will not allow us to ask more questions than that. What the question will be asked is to say that not of the thing. We demolish the case by saying that even now they have it under 163A. Suppose they want to say all the things which my lord wants me to infer will come under 163A. They did not come under 163A. Because if it comes under 163 also, self-negligence, well, it is not entitled. Legal names will not be entitled. That is the entire story.
The version of accident by the investigating agents.
There were 3 persons were going on a motorcycle. That's what RW wants evidence. I will just read that Malad not.
Charge sheet.
RW1 is your administrative office.
Well, guess what? I made an insurance company, appointed an investigator. They gave a statement was on the basis of that I put the statement in the court. Supported. Now, what is the story is 3 persons were going on a motorcycle. They caused something, some accident occurred, and that fellows were running away. This good some person started following him. Unfortunately, those people went away. This fellow landed in an accident. Good intention. He must have tried to catch out of a wrong mover. Unfortunately, destiny was against him.
So therefore, something has to go in their favor.
I leave that to the hospital court. What I'm trying to say is there is no proof of employment, there is no proof of income, there is no supporting document. They examined the
The
witness.
date of accident is?
But the date of accident is 15/10/2007. But I understand, Malak, there is no evidence of the insurance company, there is no evidence of, but in this particular case, it's not like that. There is a proper evidence, required evidence. To disown, to destroy the evidence set up by them in respect of the act. Rest of the benefit of doubt will always be there. As my Lord wants to say that there is some benefit. That will be there. I'm not saying no. But I'm not liable to be paying that amount which I'm not liable to pay. Otherwise, also it's reasonable. It comes to 10,000 rupees was taken. But it was into 12 into 17. The future prospects were not taken at that time because it was not the law at that particular time. Therefore, my Lord, that was done. So that is it.
The charge sheet may not specifically taken that may permitted to read Miller page 6 of the order. Paragraph 11, there is no satisfactory evidence to show that the motorcycle being driven by the deceased ran into the station line. The investigation done by the police, which culminated into charge sheet Exhibit A to B filed, also revealed that the accident took place due to the rashness and negligence on the part of the driver of the lorry. The police Yacharam has drawn a sketch for the scene of offense, and it shows that the motorcycle of the deceased was going ahead and the crime lorry came from behind and dashed against the motorcycle. They drawn the sketch map also.
But we believe the PW2 or we believe the lower court judge who's speaking on the basis of the material. PW2 comes and says, I was driving in the back seat, we did this. The court says, charge sheet. I leave this on the board, I can say nothing.
No, PWT doesn't say that.
The PW2 says we were going on the motorcycle. My Lalitvand is trying to redirect again that the lorry came from the back side and hit her.
PW2 didn't say that they had dashed against the stationary vehicle.
That's what he said. I read that, I'll read it again. I have said it up to 10 plus. Police recorded my statement sometime after the accident. It is true that on seeing an accident myself and the disease, but why will I ask this question if I don't have the investigation report? Why will I ask this if I don't have the RW1 who has come and spoken about the accident? I have stated in the RW1's evidence that this particular were 3 persons were going on a motorcycle. They have caused an accident for which these persons were chasing. All that I said it in the RW1. That's why I
read further.
It is true that on seeing the accident, myself and the deceased chased the vehicle involved in the accident, and during the said process, the accident in this petition is occurred.
What is the accident?
That's what I said. What was the accident? We went and rammed into the backside of the lorry.
That is what is difficult to.
I think this is what is the evidence. I can say nothing more.
The accident occurred when they were chasing somebody who had caused an earlier accident.
And it is not that
how the accident occurred, the second accident occurred is not reflected.
Let us take it for a minute.
The charge sheet says something else.
Is it now the question before the court that the motorcycle went and rammed into the backside of the lorry, or is it the lorry which came and rammed into the motorcycle? Well, let me answer that question and then pass on.
The sketch is there, he says.
Where is the proof for that? Well, the inspector himself says, I recorded the statement, this is what it is. But very rarely we have a case wherein it is at least so much evidence. RW1, RW2, Exhibit B2, Exhibit B3, confrontation, admission, witness, and opinion writer witnesses from the petitioner's mouth. I'll leave it to this on. Nothing else I can say.
Yes.
But from here in Malad, we'll have to see what is the things which can bring beneficial legislation. I can leave it.
The RW2, what has he referred, how has he dealt with the charge sheet part?
Well, charge sheet he says, but he has filed the charge sheet of the going to a person who files a charge sheet will be a person on the basis of all the material available with him. 161 statement of the person which is marked as Exhibit B2 is confronted to him. That is the statement recorded by him. In that it is mentioned that they went and rammed into the backside of the lorry.
You have B2 with you?
Yes. The policy also again is only an act policy and Malad, the third party liability, he is not, when he goes and rams into it, he cannot be named.
B2 statement will not extracted. The same also says Milord the lorry come behind the motorcycle and dashed. That 1 4 lines. As per Exhibit B2, which is the 161 CRPC statement of PW2 recorded during the criminal investigation. The accident took place when the deceased was proceeding on the motorcycle and the crime lorry came from behind and dashed against the motorcycle. 161 statement also says same. And they draw sketch map also.
So now the question is whether the witness's evidence has to be considered by the court or
There is, you are having some material in Exhibit B.
We wanted to infuse this material into the gap.
Leave this honorable court. My lord feels that my lord, the PW came and said that we were chasing, and then the FIR is said that the person came from the backside and dashed. So that is what has to be understood, but I can say nothing. I better not argue further.
That is what the content of the charge sheet is also.
But the charge sheet itself is demolished by examining the inspector who came and filed the charge sheet. His evidence is there on record, and then we have confronted in the document that itself goes to show that the document is contrary to the charge sheet. Regards the criminal proceedings. We have.
What is that material available to show that the deceased while driving the motorcycle had dashed the stationary vehicle
161 statement
of
the PW2.
What he is reading.
this is exactly what he read.
But I'm not going to see the document itself. I should be read what has been.
Read, but please read that. Even if it is Telugu, you can read it loud.
I don't.
Except for me, you are also handicapped.
I was always a Chandigarh playing colored. I studied in Chandigarh and
You are also equally handicapped.
yes. But I somehow managed to cross examine so many witnesses in the lower court, like making the they not think that I have to go so deep.
No, you can take assistance of the counsel who had conducted the case before the trial court. You have the.
Maybe we need 2 heads for this case to argue. Yes, long back in previous question. I'm not saying that Millard, that much of evidence is not there.
Our difficulty is setting aside what has been already.
I'm not saying that I'm saying Millard, let it be quietly closed, Millard, and the matter can close out. Last time when the matter came up, Mr. Kalen Roy is no more. Millard had said that we will close it like that only. We'll confirm this order and then we will close the other part. That was a little discussion which was my Leonard judge was not there, it was the earlier judge. And I had taken time to put notice to the other side so that they can come and appeal.
You wanted the help, you wanted to help them.
No, it's not that, but it's, as an insurance company, I purchase liability. If there is a liability, I'm bound to pay the liability. If it is 1 rupee or 100 crores, I have to pay the liability. It is when the beneficial legislation. We want to close the matter so that they can get their money and then they can enjoy it whatever way. I'm not saying that, my lord, that I'm saying that the 10,000 was given. I'm also saying that future prospect was not given. I'm also saying that there was no basis for giving 10,000 also. Therefore, my lord, we have to reduce it down to 4,500 or 5,000 and then give them the future prospect and then set it right. I understand, my lord, when I'm coming to this court, I understand my lord's earlier cases, how my lords have dealt with it, what questions will come. But when respondent evidence is not there, I'm only telling the court, in the law, any other place also. I'm telling that no evidence of RW, no evidence from the respondent, policy document has been filed. That is how I start my argument so that I can say, no evidence, only policy document, therefore leave it to this honorable court to pass appropriate orders. There is my narrative is relying upon the sketch too much. The sketch is there. The vehicle is on the back side of the lorry.
No, we want to know the statement of BW2 yet. You were saying that.
61. But it may be taken up tomorrow.
No, not and now.
My learned but is still insisting that it was the lorry which came and dashed behind. That was totally contrary to the entire evidence on record. PW2, RW2, RW1, the exhibit P2.
Not PW2. He read the statement and which has been reflected in paragraph 8 of the impugned order also. The statement of PW2.
That's what, when he came into the box and we cross-examined and he admits that 161 statement is a document.
He does not admit that they had been hit by a vehicle. I mean, they had rammed into a vehicle from the rear side.
That's what is the case. He rammed into the vehicle, but Melanie and the court tries to say it came from the backside and dashed into it. That's the reason why. And the judge is saying that, my lord, the accident will be negligent driving by it. There was no driving only. Placing of the vehicle, if my lord wants to say where it was placed, driver was not examined. That slot was not proved. So we cannot give a benefit of doubt. But when this case is now whether it is hit the back, which vehicle came and hit from the back? If that is so, my lord will have to appreciate the evidence which is on record. But I understand, my lord, that exhibit B2 is not there. I have to get it. Other court records also. The first, my lord, they marked only exhibit A1 to A5. But even according to PW2, the chief examination.
We have the responses myself.
When the evidence of PW2 was demolished, the reason he says it was from the back side. Lorry came and
Who PW2?
yes, this chief examination is that because they consistently the PW1, PW2 remained like that only. PW3 was nothing to do with the accident. He also
The
talked
name of
about that.
PW2 is?
PW2 is Shaker. A Shaker, son of Changai.
Yeah. In his chief, he says that.
In his chief, he says that one lorry number 2 came from our backside, drove its driver in a rash and negligent manner, high speed without calling traffic, dashed the motorcycle as a result, so and so. So he also tries to say from backside.
Gotcha.
So that was demolished by his cross-examination, by his statement given in the hospital, and by the statement given by the inspector.
In the cross-examination, he says that it is true that on seeing an accident, myself and the deceased chased the vehicle involved in the said accident, and during the said process, the accident in this petition occurred.
Now, according to them, let us take it not this is the accident occurred.
It is not true to suggest that due to the rash and negligent driving on the part of the deceased in chasing the aforesaid vehicle, the above said accident occurred.
But that always will be like that only. Even if it doesn't say it's correct, it will be recorded like that only. Well, in the cross-examination, it will be recorded like that only. Not true, not true, not true. But now, let us take it. Now, in this question, let my lord may see the evidence of all the
PW2 has not controverted his statement.
Yes.
Where is that?
This, but in the first page he says, it is, in the chief examination he says,
the lorry came from the lorry side. Yes.
In the cross-examination he says, they were chasing. When they were chasing, the accident occurred.
They were chasing another vehicle, not the lorry.
That's what I'm saying, my lord. If he is chasing another vehicle, from where will the lorry come? If he is coming from the opposite direction, it is not his case. It's coming from the backside. How will a lorry be chasing a motorcycle which is chasing some other motorcycle?
The lorry speed is higher than the motorcycle speed. This can very.
It shows that it is standard. The station card filed by them, it is not saying that it is on the right side, it is going, it is showing that it is parked.
That evidence is lacking. Whether somebody has seen the lorry already stand in a stationary condition and the deceased going and ramming into the rear side of that lorry. That is missing.
1 minute. RW1's evidence. The RW1 is the officer, he says that it is respectfully submitted our insurance company secured Xerox copies of the document from the police station in Amsterdam, Cyberberg district, where R. Devendra, SI of police, recorded the statement of one Shaker, that is PW2, son of so-and-so, president of so-and-so, Mangal, case diary of part 2, wherein he stated that after playing volleyball while he was standing in the village gate, at that time, 3 persons were proceeding on CT 100 motorcycle from Nagarjuna Sagar to Hyderabad and dashed to one person near the gate and trying to flood away without stopping the vehicle. And by observing the same, himself and the deceased tried to catch hold of the CT 100, started chasing the vehicle. And when they reached near police station Acharam, then at that time the lorry driven by his driver in a rash and negligent manner dashed with a motorcycle, resulting in grievous injuries to him. That is it. But now, his version which came on the basis of investigation and on the basis of evidence also doesn't believe, because they say it is not the vehicle which was standard, but the sketch shows it went and dashed into the motor lorry. Then it is further submitted that contrary to the above, the injured while taking treatment in Kamineni Hospital, that is Exhibit P3, stated that same person, Malad PW2, went to the hospital. He stated that we rammed into the vehicle. That is Exhibit P3 FLC. So PW2 plays an important role. He is a million rider. He gives a statement to the police. He gives a statement in the hospital. He comes and says something different. That's why not 3 versions were argued.
The BWP3 perhaps is the only document which reflects that the accident occurred in the course of the deceased dashing into the stationary vehicle. The difficulty is when PW2 was examined, he was not confronted with B3.
But that particular document, let us take it like this, it was not confronted to him, but his statement is recorded by the inspector.
His statement
is not signing the paper. 161 statement is not signed by him. Who do we confront? To the person who has recorded the statement. The SI says it was recorded and then it is placed in the record as part 2.
It must not have been definitely recorded by the SI.
But SI will not be able to write a story.
Therefore, believing that also would become difficult.
I leave it, I'm not saying anything, but what I'm trying to say is, no person can write a story on the basis of, unless it has been told to them. 161 statement is a story written on the basis of which is filed in the charge sheet. And the charge sheet itself is faulty because of these 3 latches. That much as Lord says, suggested that PW2 was not confronted, but it is a statement recorded by the police. Police was confronted. The person was recorded in written. But here, the PW2 was never, they did not cross-examine. The petitioners could have cross-examined that particular portion of the inspector. They did not.
The PW2 would have taken the safest of argument that I was in the hospital, I would not.
Yes. I just occurred, I was unconscious. I got up, I saw the number, I remembered the number, I got fainted. Again, I gave the number to the inspector. Is the statement with
rest is what? Rest is the story cooked up by the. Then that was the reason why he was not confronted.
Yes.
Otherwise, this ground also would have collapsed.
He himself says, I was discussed about it afterwards. He remembers everything because he was comfortable by the time. Usually, what is the evidence with all the 34 years of standing with the insurance company? They say, I fell down, I became unconscious. Suddenly, I got up, I saw the number plate, and then again I became unconscious. Well, the appeal grounds filed by them is for the purpose of enhancement by saying this is not considered, that is not considered, but with a delay of 359 days. That's
See, the charge sheet is by the same person. PW3, RW1, RW2. In his charge sheet, just above his signature, he has said that the motorcycle bearing so from the backside was proceeding towards the deceased.
But there is an inconsistency from the prosecution itself, the inspectors and all of them. But it happens like that only for the reason that if they write and say that the person.
Only dashed the motorcycle. This is what the story by the same person.
That's what I'm saying, my lord. Three different stories are there. PW2 is the most important witness. He says it in the hospital. We were not there, investigator or not, the police was not there. He went and then he was referred by the police to the hospital. He went to the hospital and he said, he ran to the bed. So they were an ambition and they said, at least three, this thing, no one was there to coerce him or say something.
That document does not have his signature.
Well, it is. I am going to the hospital, I am admitting myself in the hospital.
Believing that will be difficult.
Tell them whether I'm allergic, I'm not, what is my height, my weight, my age and all that. I go and tell them I'm male or female, something like that. Then only they record the document. My lord, if you see, my lord, that is not okay. But they are very less points nowadays, but as regards 5 years back to now, we are nothing, we are just standing, addressing and then leaving it to the honorable courts. But there is a case made out, my lord, the PW himself is a witness examined by them on their own violation. Uninfluenced personal statement.
What do you say for your appeal for enhancement?
Enhancement, my lord, is a lecturer, my lord, the principal was examined, my lord.
What is the evidence?
Yes, my lord. PW3, my lord, Malla, the principal of the
documentary evidence.
This documentary evidence, my lord, he filed, my lord, salary certificate, my lord, he was examined, my lord, through the same was through, my lord, to PW3. Coming to the issue number 2, my lord, page 8 of the order.
A6 is the salary certificate.
A8, my lord.
No, A6.
A8. A8. A7 is the ID code of the deceased, my lord, issued by the PW3 college.
The identity card is not of the deceased.
Identity card of the deceased issued by site of A7.
The PW1 does not file any of these documents. To say my husband was working here, there, and all that. AC files only 5 documents or 6 documents and goes off. Then they bring these documents to the person who is not even issued a notice to come as a witness. His first statement in the prosecution has not been put to notice. He comes with the papers, properly stitched and then filed before the court and marks as exhibits. But that is subject to proof and relevancy. Proof is to be there. He says in the cross-examination, Maharaj, there is no attendance register. I have not brought the attendance register. We pay everything in cash. The 32 employees. It's a hospital. It's a college. It will be owned by the government. I don't have anything. It's being taken in the acquaintance register. If that is to be believed, then nothing is to believe.
Specifically says we produced the documents also before. The aid will not be only one parent, but half of the parent. PW3 exam, we speak about the income. He is the principal of the Sai Gautami Degree College, Ibrahim Patnam, and he reported that the deceased was working as a senior lecturer in physics and was drawing a basic pay of 8,200 and also 1,000 towards HRA and 1,000 towards DNS allowances. The principal of the college has produced the documents to show that the deceased was working in the college. He is elaborately cross-examined by the learned counsel appearing for auto insurance company, but nothing concrete is elicited from him for disputing his claim that the deceased was working as a lecturer in the degree college.
Is it acceptable that college professors are being paid salary in cash?
Those days,
Which days? 2007. We are not talking of any ancient period. 2007.
Even 2017-18 Millard, all the employees are paid cash only. Millard. Now Millard are being paid online account and GPay account.
Millard will appreciate the cross-examination.
Salary was always paid check. Now from 2017-18, the checks are also not being paid. It is all being credited directly to the bank. Salary all along was being paid by salary check only. It is hard to accept that the basic salary, the HRA, the DA, everything paid in cash.
So it's a 2007 accident in Millard.
But he says, it is true that if a person is to be designated as a senior lecturer, he should possess a doctorate degree. Here again, he says that seniority I have said on the basis of his something like age, height, and weight, and all that. And he doesn't say about education. They don't have the education documents with them. But they say that BA honors, BSc. Then they say we are running only MPC, NPC, and CEC. And then he says this particular person is a physics lecturer. And he says, Malad, I have not brought the registers today. Salaries are paid in cash. Signature of the employer taken in the acquaintance register when salaries are paid. I have not filed any acquaintance register or other document.
What was the qualification of it?
That is also not supported by any document. There's another eligibility test also was there. One more thing, they should have an eligibility test for being an employee. It is stretched to such an extent and test. Witness says that these college lecturers are called senior lecturers or junior lecturers, having regard to the length of their services.
Those
Can be considered for enhancement, Millard. I filed profit in Millard.
that is why we are asking you what is the scope of material available, even to accept 10,000.
The employer of the district in Millard is examined. He was produced in Millard. The document has for the evidence.
What is that document?
It's a
Salary
salary
certificate is a salary. Have you seen the document?
Yes.
Have you seen the document salary certificate? Just see, Is a salary certificate normally issued in such manner? It's a letter issued on a letterhead of the institution. And you say, claim it to be a salary certificate. That is not how salary certificates are.
Given on the letterhead of the college.
That's what I said. It is only a letterhead of a college in which certain contents are typed as salary certificate.
Wherever requests are on my submission, that wherever requests will salary certificate, we obtain the same format.
No. It would be in a printed format. The salary certificate would always be in a printed format. It will have the month, but complete details of the employee and the necessary allowances.
But if they small that
It has to be reflected there. Then there will be necessary deductions. What? Leave it to
only my submission that already was examined the employer, not suppose it will not. This lecture will consider that aspect.
lecturer, minimum qualification has to be post-graduation. Where is that? You have not even mentioned that. Is there any averment so far as if you are looking at the board as if your number is coming somewhere else, we can have it on some other day. We are not in a hurry.
I'm not in a hurry.
Then,
there is no other material.
so what is the material that we can take?
Only my submission before the sample board. The employer is examined before that.
No, look at the material that the employer has produced. He has produced certain document which is hard to accept and which is not the normal salary certificates which are issued to an employee by an employee. And look at the identity card. You have the identity card.
Lower court observe that.
This again is on a piece of paper. This again is on a piece of paper. And look at the next document. That is the identity card of the principal. That is in a proper format, in the form of a card.
He left the card there. That means he doesn't require to go and make that more.
He is the principal. He can make as many as he wants. So therefore, there are great element of doubt so far as the income is concerned. So what is the best income that can be taken? You suggest.
Would consider the graduation will 10,000, 10,000, 12,000
2007. We are struggling with the insurance company even to accept 10,000 in today's.
Well, there is a proper proof. We settle the matters. In fact, as a judge, not me seeing how many cases are being settled. Now, there's not going to be appeals, all the matters only when there's a point where coming appeal, otherwise they're not coming for.
10,000 doesn't seem to be justified.
But there is no basis for it.
Difficult to digest.
In future prospects,
that we will add. That we will add. We will reduce the salary income part and then we will add that. What was his age?
27.
27.
17 is taken.
That's correct. 17 is correct.
But that also no proof. That age also there is no proof. It's only an admission on record which we and then the insurance company did not file the birth certificate to say it is wrong.
No, since there is nothing in rebuttal, to we will accept whatever is the finding of.
That's what I'm saying. And there is no rebuttal that I did not file the birth certificate, I cannot say that it is not what it is.
We'll take 7,500 as the income.
maybe on the higher side. At 2007, my lord, it is around 5,000, 5,000.
Our conscience does not allow to reduce it further down in a death case. Not that we are disbelieving you or we don't find force in your argument. The fact is, there is something in favor of the claimant.
These are the cases whether my lord will have to appreciate one more angle. The owner of the vehicle is primarily liable. But he has to come to the court and give evidence. He does not come and give evidence. He does not say anything and he allows the insurance companies to bleed. But court should say, my lord, what to do. There is a case where when any payment is to be made under paid recovery, first insurance, the owner has to give security. There are one or two judgments to that effect. That is not being followed. Not paid recovery is being ordered. Everything is going. But solely an operations are
At whose instance?
I think the insurance company should have a center for the purpose of taking every parameter of the thing as reimbursement compensation and all that. How many employees, everything should be collected and not to give any discount.
Will reject the appeal of the insurance company. No, sorry, partly allow it. So far as the income part is concerned, we make the quantification with 7,500. Yes. 40%, not 50%. Future prospect. But test, there everything is test. What about consortium? How many claimants?
But two really mother was not, we don't know. Mother died.
Consortium part also goes only my wife.
Yes, I say.
40 plus 30. 40 plus 30, 70,000. 40 has been granted. Has it been?
But if 7,500 is taken, then some sort of 14 lakh next case also. With all the.
Just forward it.
I'll read paper and give.
Loss of consortium is given 10,000, that will be enhanced to 44.
Taken as 40.
44.
40 plus.
Yes, call the meeting 45.
Mature.
45.
Please, please, Lord.
Yes.
Lord, the matter arising under the Motor Vehicles Act, Lord, the claimant's appeal. Lord, the petition is filed not to receive the documents, Lord.
It is high time now you should refuse appearing in MACMS. An appeal by the claimants.
Yes, Lord, appeal by the claimant, Lord. Lord, the claimants have filed the IA, Lord, IA 1 of 2023. Lord, to receive the income tax return acknowledgements, Lord, as additional evidence.
Who appears for the insurance company? You were there. How much is the?
Lord, the claimants claimed not the 33 lakhs 75,000 rupees, but the lower court awarded 7 lakhs 22,000 rupees, Lord, taking the daily wage at rupees 200. He is the Lord, is agriculturist and is having real estate income. Lord is cultivating about 51 acres of land, Lord, in the near Singur project. And not the lower court will not have taken the income of the deceased Lord at rupees 200 and awarded 7 lakhs 22,000 rupees.
Date of accident is 16/2.
Yes, not 16 to 2012, Lord.
First of all, yes. The IAS ought to be allowed. The thing is, I filed my counter. The IA is filed to receive the documents and mark them. And what is filed is income tax copy of the income tax acknowledgement. And I have sent the copy to the company. They have appointed an investigator. The investigator reported to the company that I filed my counter in para 7. They say the three company has appointed an investigator to ascertain the correctness, authenticity of the income tax acknowledgement for the assessment year 2011 and the income tax return for the assessment year 2011. But the investigator has reported that he is unable to verify the IT returns which are filed manually. So, under these circumstances, to mark them, prove them by examining the income tax department of HMR. By consent, they cannot be marketed here. Because in the insurance company is
even if we accept it, it is only 1.5 lakhs per annum.
But the document proving the document by consent. The insurance company has appointed an investigator and he has reported that he is unable to verify the correctness because they were manually filed during that period. So under these circumstances, marking them.
No, we would not mark them.
Unless they are marked, there is no evidence on record is not believed by the
Lord, PW1 to PW5 were examined, my lord. They all said that he is having agricultural stand, is cultivating about 50 acres of land, my lord. And my lord, the lower court has taken, my lord, and he is used to get, my lord, 6,000 rupees per acre.
That land is still with the family.
No, my lord, he is taking lease, my lord. Land is not with the family, my lord. He used to take the land, my lord, on lease, my lord. He used to pay rupees, my lord, 5,400 and 6,000 per acre to the landlord, and he used to cultivate and get the income from out of the agriculture, my lord. And my lord, he is also doing, my lord, the real estate business. My lord, the PW1 to PW5 was categorically stated, my lord, he is doing both real estate and the agriculture operations. But the lower court, my lord, is taken, my lord, the 200 rupees per day and my lord fixed the 6,000 rupees per month. And my lord, after deducting 1/4, my lord, he arrived 54,000 my lord per year. And he applied the multiplier, my lord, 13. Lots of are not even agriculture labor salary wage is not about 600 rupees per day.
Who's PW 3, 4, and 5?
Milord, PW 3 is Mr. 1 Bhargav Reddy, Milord. whose lands have taken by the deceased lord for cultivation purpose.
3, 4, and 5, all three.
Yes, not 3, 4, and 5 lord. And PW1 is the wife lord, PW2 is the eyewitness. And the claimants are Milord, the wife and the children, Milord. Because the insurance company has not filed any evidence, Milord, except the policy copy, Milord, to rebut the evidence of PW 1 to 5.
What is the date of submission of this income tax return?
Milord, the submission of the income tax, I mentioned, Milord.
11 is 21/6/2010, Your Honor.
21/6/2010 and 6/7/2011, Milord. For adjustment year 10/11 and 11/12, Milord.
It was prior to the accident.
Yes, Milord. You know, he used to get not a minimum 30,000 rupees per month, my lord, as a.
That is even more than your income tax return that you have shown.
Because, Lord, the agriculture, your lordship is aware, my lord, that agriculture income is exempt, my lord. He files return, my lord, only the real estate income, my lord. Agriculture income is a exempt.
Difficult. To what extent can it be enhanced? 7,500.
When I started taking submissions about the interlocutory applications, my friend at senior council started arguing the case as if it is final hearing. The interlocutory stage minute, we have not crossed it. Whether or not the IAs are to be.
We would not mark it.
Right.
Those documents, we would take it, but we would not mark it. We would proceed to decide the appeal on.
If they are not marked, well, they cannot be relied upon.
We are not accepting that also. We are trying to reach to a
Very
reasonable.
If it is to be finally heard, but I will be very brief. That the income that is claimed is on two counts. One is agriculture and the other is real estate. So far as agriculture is concerned, not a single acre is in his name. The claim is that he took 51 acres on lease. No lease deed is filed. Only Makta receipts are filed. Makta receipts are marked as exhibit A10. And Shawfasla and Adangals are filed as exhibit A11.
Yes.
The tribunal refuses to believe them because the name of the deceased was not mentioned in the, at least in possession column. It will be mentioned if he has cultivated. That is not mentioned. The tribunal refused to rely on exhibit A11. Then the agricultural income goes. The real estate income. Nobody is exempt to prove the real estate income.
Yes.
No evidence is accused to show the real estate income. Under these circumstances, the tribunal is constrained to take 6,000 rupees.
Subsequently, there are certain income tax returns produced on.
That is exactly what that is why I said IAS have to be decided.
No, we are not going in to mark those.
They cannot be related.
There is some element of evidence to show that it has been filed much prior to the death of the deceased of the previous years.
They have to be marked.
We may not, if it is marked, then we will have to accept the entire thing as income.
Yes. I have no difficulty if it is marked properly. That whatever income is there, that will have to be taken. If it is not marked and relied upon, that will be will not be proper. Even if it is 10 lakhs or 1 crore, if it is marked in a proper manner, that will be appropriate. If it is not marked, they cannot.
Have you filed your counter to this?
Yes.
Lord, counter didn't say anything, Lord, except saying, Lord, he filed manually. His surveyor is unable to verify the ID returns. There are 7, Lord.
Where is the counter?
Page 3, para 7, my lord.
You have counter to this IA?
Yes.
Where is that? There are 7 years.
And then
Since your surveyor has not been in a position to ascertain it from the department.
yes.
What is there now to disbelieve these documents which has a specific endorsement from the.
But it is on the petitioner's to prove that. We made our efforts. When copies are served on us, we made our efforts. The applicant also filed a representation for the ITO. The endorsement is very much of it.
What is that?
That's quite copy of the. If something is if passed across the bench where we have no opportunity of either.
Where is the original?
Original copy is your version.
Then we'll have to produce the original on record, we'll accept it.
Yes, definitely. Yes, I'll file with a critical minute so that we can. Across the bench, if papers are just.
No, this is only an internal correspondence. We are not keeping it. This is only that. This we are going to give it back. No, this is only to show how they obtained it.
Even in the court merit, if I find such a friendship merit, will they be taken? No.
Under MACT, definitely we will. May not be under the other civil laws.
Tomorrow I will take an opportunity. Let's see whether
from the side of claimants, we will definitely accept. Can you produce the original before the court?
Yes, I will try.
When?
Next week.
The learned counsel for the petitioner is directed to produce the original.
Yes. Simple hypertensive insurance that is disposed of. The order is not uploaded. Let that file may be called.
MACM, which is that MACM number?
34 of 2019.
34 of 2019. When was it disposed? Recently?
First 2019.
Just get the file.
Lordship script permission.
Yes.
55 and 56. Present the respondents, your lordship, and only have this matter on Tuesday, we are not going to receive updated instructions.
We don't make a request for Tuesday, next week will
Yeah, anytime next week, we are not, I will inform that this.
first week of December, sir, would do
My item 66 has well.
6 and 7, 55 and 56.
Yes, item 66.
6th of December.
Yes, my lord.
Which is the other one?
66, my lord.
Yes.
Yes, your lordship, may kindly have it, anytime, my lordship, please.
This is a matter of 2008.
Any day, your lordship.
7th of
Okay,
December, 7th of December. 66. Then you are the council in that also.
yes.
Yes, we are the same.
Item Shashikan is not going to request it for tomorrow or Tuesday.
Go on, Wednesday, Thursday.
Yes.
16, that's the request of the council. Council for the first response. He appears for the first response.
Yes.
16th of November.
Item 67
Yes.
and my lord 87. Watchman tomorrow or Tuesday, my lord.
Tomorrow there will be difficulty. 67 and
67 and 87.
15th. 87 is a batch matter.
It can be disclosed. It won't take much.
15th of November, next Wednesday.
Next Wednesday. Next Wednesday, you have to post it in batch matters.
This you said would not take much time.
But I thought, Tuesday, it will be.
Tuesday we have already fixed many matters. So this may go down the list and it would not reach.
Sorry for making this request. Tomorrow, my lord.
Tomorrow is Friday.
Yeah.
The bench would have to, there will be single bench.
Wednesday.
No, we can take a try on 14 Tuesday, just take a try. 14, 87 to 91.
67 and 87.
67 as well. 14th of November. Just take a try. Yes.
Yes. It has.
4 marks. Total 4 marks.
For
So
the
one
first
by
one. Yes, yes.
Item 36, 37 are also passed over. I think may take some time. I may consider taking up my 42 items. It must be to take the time. It takes some time.
Yeah, yes, yes.
My lords, item number 53 and 63.
Just one second. Just one second. You want 36, 37 to be taken first.
No, 36, 37, any account first, not. Any is 42. They matter may take some time. That's the reason
Their matter would take days.
That's why they have to re-argue the matter.
Altogether, that's what I said, it may take days. That was the reason. Initially,
Let them finish their matter.
just wait, the 2, 3 classes will take up that.
My lords,
Just one second, just one second. Yes, yes, yes.
my lords, item number 53, 63.
Yes.
And 104, 105, 106, and 107.
Yes.
My senior was about to argue today, but he is suffering from bad throat since morning. So we request you to post this matters after 2 weeks, so any date.
Everybody suffers with that. That should not be taken too seriously.
No, my lords, if he is seriously not feeling well. In fact, he has posted his Supreme Court matter also today.
2007-8 matters. It would remain in the list.
That's the reason, my lordship, I am just requesting it to postpone after 2 weeks because he has been detected total infection. It will take little longer time.
No, what I'm saying is that this is a 2007 matter. If it doesn't reach today, it would automatically get posted for week after next in the not reached list. It would remain there. We need not pass an order for that subject. Finally, matter.
My lords, still I will request because every day he has been waiting online, and now since he is not feeling well, I request you to post it after 4 weeks at least.
Now, when do you want it? When do you want it?
Any date after 2 weeks.
Because you would be in a better position. You give us a date, we'll keep it at the top of the list on that date so that he gets priority.
Yes, my lordship, just a moment.
When?
Just a moment, my lords.
20th of November?
28th maybe or 4th of December, my lords. Because it's marked.
Take a date in November. 20th or 28th also is fair enough. 28th, this month.
That's fine, my lords. 20th of December.
Now give us the number 53.
53, 63, 104, 105, 106, 107, my lords.
At the request of the council, petitioners list this case on the 28th of November. At the top of the list.
No problem.
It is already one. And it is already from income. This matter is old matter disposal. Yeah.
Little bit of this. 4 minutes dismissed the appeal, insurance company. And putting order before.
Now you argue on behalf of the appellant.
It's a case of injuries, no? Case of injuries.
How much? What is the possible?
Claim is 50 lakhs, no? Amount grant is 30 lakhs.
Yes.
Date of accident is 14 March 2012. Where the injury is C6 and C7, spine injury. Fracture C6 and C6 and the fracture dislocation paralyzed to the whole body.
That is what I was about to say. That is one area which is totally incurable.
Yes, that's true. Because once C6 is incurable, it's spine injury. It's almost it's
not be in a position even to stand.
Or quadriplegia, it must be paraplegia or quadriplegia. He was aged about 34 years.
So it will be 100% total loss of.
But it's the tribunal, that's I will come to that point. But the tribunal is considered 25%. You know, so please, so it will take 50%. That's what I wanted to bargain to that extent. Because
how 50%?
The judge has given a reasoning for that. Then your still, I invite your lordship kind of attention to the because
is he not bedridden?
Because I do not know, because I'm seeing this nature of injuries, definitely TSHC 7 spine injury, he cannot move from this. But the fact remains, even with the appeal, the councils they did not appear, not even a chair, because in the morning I was impressed the moment I came to know that since they have even already ordered, they are not appearing before this court. But even then, today also, they did not choose to appear before the court. At least, as the council is present in the court, at least the court would have
seen
what is the discussion.
Non-appearance of a council could be for more than one reason.
Other day, when they say same case of this nature,
you are
yes,
witnessing daily.
Yes, sir.
How many matters the council for the claimants are representing?
And the judge, why he has disbelieved is 25%? Because no doctor of consent was not examined.
No. Who was examined?
Well,
on the claimant side.
No,
Claimant side, claimant.
Yes, claimant side examined, but the court find that is a strong doctor. Well, page number 8, that was observed.
No, what I wanted to know is suppose on the claimant side,
yes,
was he examined on commission or did he appear in the court?
No, a doctor was examined. Well, you will still find it page number 8 of the judgment. Because the doctor who treated him.
What is there? Because
Well, that before I just
yes.
paragraph 20, I just it starts from this thing. It will end with the petitioner contended that sustained disability. Petitioner got the find a disability certificate on the DNA issued by the government area hospital Kondapur. In proof of the same, he got examined Dr. Sulapani SPW3. He stated that he is a practicing orthopedic surgeon for the last 20 years and also medical board member in area hospital Kondapur. He stated that he assessed the petitioner had sustained 90% disability. During the cross-examination category, he stated that he never treated the petitioner as patient at any time, and he assessed that the petitioner has 90% disability. It is to be noted that how a private doctor being a member of the medical board and working as an orthopedic surgeon in area hospital Kondapur is not known to the law. The documents filed by the petitioner shows that immediately after the accident, the petitioner was treated in area hospital Nandya. Thereafter, he was treated in King's Hospital. In month of August and month of September, Ram Hospital. And November, he was treated in BBR Super Specialty Hospital. In the month of December, the petitioner was treated in Unani Clinic in the month of October. He was also treated in Arya Vaideshala at Kerala. Except the treatment from the October to December, the petitioner has not filed any document that he was still under the treatment. The petitioner has not examined any doctor who treated him. And this court has observed that Dr. Sulapani, who is a staff witness in heavy offences, his evidence cannot be disputed. Well, every day he used to come to the court, because we have the two doctors. One by name is Sulapani, other one is Dr. Subhash. These are the two doctors regularly will come to the picture. These are the two doctors who give evidence either in the civil court or in the WC court. Therefore, there is a categorical finding by this court, so the evidence cannot be taken into consideration. Well, relying on that evidence, that's in view of the discussion, the petitioner is miserably failed to prove that he sustained disability. The nature of injuries clearly shows that the petitioner had disability, but the way in which the petitioner wanted to clearly shows that he suppressed the real facts. In this court assessed that due to dislocation of C6, C7, near total part transaction, the petitioner would suffer 50% of disability. But my lord, I will help at 50%, then learn get again 25%. Well, then this court, because as far as income is concerned, the court considered 3 years of average income. Well, that has taken 2,35,166. Well, that page number 10, it's loss of 25% prospects. However, it was sufficiently compensated. Where in the case of pain and suffering, there 9 lakhs was given. Nine lakhs 40,664 was given towards a 25% disability. He was in the hospital for 3 spells, 15/8/2012 to 29 August 2012, 13/10, 17/10, 7/11 to 10/11. In fact, even if we consider 25%, it comes to as good as this court is giving some 75% of the disability. Because 9 lakhs was already given under the towards the parent suffering.
He sustained permanent disability and suffering from total paralysis of his whole body.
Yes, well, that's absolutely once C67.
How 50% and how 20% and how 25%? What is the justification for that?
Well, it's according to their certificate color, it's 90%.
What is the loss of income capacity total? So it has to be 100% for the purpose of computing compensation.
Once it's final injury, yes, that's we do admit
that apart.
Yes.
The amount of trauma and agony that he has undergone for all these years, that is much more.
You're also so please kindly of this matter tomorrow minute, because it is it's not that I require it's with the because petition advocate, that's right. Because one is Tirupati is appearing. At least let us know the fiscal status of the petitioner. At least some as of today, that's it's only for today and tomorrow makes my difference.
No.
Because only thing is, if you really is still bedridden mallet, we are doing the 100% justified mallet in giving that 100% disability mallet. Because this I know this advocate mallet, I'll contact with this advocate and make a call to him. At least we will know what is the fiscal status of the petitioner. That's that one area that's I want to tell you. If really this court is granting, at least we all of them are doing 100% justice to it. That's all. That is what is passing in my mind.
Tuesday.
Yes. If necessary, then I ask the council to come to court also.
This is not of no use now.
Well, let's keep it
around. Keep it around. That is the request of the council for the appellant.
So that tomorrow I should not think that I committed a mistake or mistake committed.
34 is there.
Yeah, for the responded claimants for morning possible.
This is 30, 35. 35. There is absolutely no ground. There is absolutely no ground available, madam. We are, show us one ground available to keep this file or even admit it or notice for the other side. There is nothing. Appeal for the sake of appeal by the insurance company.
They have claimed 50 lakhs, 69 lakhs, 44,020.
Only on that ground the award does not become bad.
That is not ground.
Look at the facts which has come on record.
Next week, any time, I will prepare and come. Next week, any day, final.
14th, top of the list. So that you are not held back for the whole day. We'll free you in the morning itself. 14th, top of the list at the request of the council.
This is not
so that I can
item number 8. Item number 6. The registry is directed to reflect the name of the at the council for the insurance company in the cost list. this. Yes.
Regarding the provisional not attacking the plan. Without recording any reasons, I relied on judgment, but I have two more judgments and one judgment of our right court. So the record. Yes, I have a lot of papers, not the last time one by one, there doesn't say confusion. I was unable to put it in a.
What are these?
One, the first ground he raised is that the order original was not served, sorry, the attachment order was not served on him. So I have proof to show that at his registered email address in the TSHC department, this order and original was served
On the same day.
on the very next day.
On the next day.
On the next day. I pass on that since I made that submission. Pass on one by one. Two things I will establish from that. But that is at the behind of the page, you also will see the image. And what document that I've also given you, Lordship, is the registration details. After the pink line, it will show that this is the registered email address. The submission that this was not served on him, and then he got it with great difficulty from the bank.
Yes.
But you can see the email is dated 19 May at 11:29 AM. The order of attachment is on 18/5. Lordship, I've taken out copies of the files of the original page. Second ground that was raised was that the now by relying on a circular. So the first is a synopsis test for your Lordship's consultation. That brings out the entire facts. It shows that we have got information regarding this entity from all over India, not just Hyderabad, from Calcutta, from Aurangabad, etc., which is part of this record as well. Not being put it. And these information alert notices have also been shown to the petitioner when summons were issued to him and his statements were taken. His signatures are affixed on these alert notices. So it's not like he does not know what was happening. So just taking a Lordship to show that on what basis the commissioner now knows the record. This is part of the record of this note. Not the synopsis, the rest of it. Lordship will see right on top, there is a note 1, top left corner. Now, presently, I'm instructed that how it works, everything is e-office. Earlier, you could backdate, put something, those allegations were there. Now, everything goes by this e-office by way of a note. So, this even today, if anyone goes to the e-office, these notes will be as is. Lordship goes to the next page at the end of this note. Third page, Lordship will see the next is note 2. This is third page. I'm just showing you, Lordship, how the e-office works because there's an internal record. Just to satisfy your Lordship that the attachment has been done after having enough material on record. So that's note 2. Now I'll read note 1.
Yes.
Brief of the issue relating to Messrs. Ardent Trading Company is given here. Messrs. Adil Trading Company is a partnership firm for trading various types of scrap and registered with GST and so on. So Sri Mohammed Ibrahim is the managing partner of Messrs. Adil Trading Company, so and so, and their principal place of business is so and so Telangana. Messrs. Adil Trading Company falls under the jurisdiction of Hyderabad GST Commissionerate. Hyderabad GST Commissionerate and allotted to the Center for the purpose of tax administration. Messrs. Adil Trading Company filed their monthly GSTR preview returns for the period of July 2017 February 2017. Intelligence received by the officers of Anti-Evasion Wing, Hyderabad GST Commissionerate showed that two different firms by the name Messrs. Hindustan Traders, Kolkata and Messrs. Kedar Enterprises, Kolkata were not operating from the declared place of business and have passed on input tax credit to Messrs. Adil Trading Company to the tune of rupees 7,25,112 and rupees 36,576 respectively, totaling to rupees 7,61,688. On analysis of intelligence, it was noticed that Messrs. Hindustan Trading Kolkata and Messrs. Kedar Enterprises are not functioning from their declared principal place of business, and Panchnama dated so and so 27/1/2021 and 27/1/2021 respectively were drawn by the officers of DGEISP Kolkata Zonal Unit to the said effect. Sri Sujan Ghosh, proprietor of Messrs. Hindustan Trading, and so and so Meghanath Chaudhary, proprietor of Kedar Enterprises, in their statements dated 16/3 and 25/3/2021 given under Section 70 of the CGST Act 2017 respectively before the Additional Assistant Director so and so have confessed that they have traded the invoices without involvement of goods mentioned in such invoices. They have never supplied any material and that they have generated fake invoices with an intention to pass on ITC fraudulently. On being intimated regarding the stated irregular ITC avail, the taxpayer Messrs. Adil Trading Company have reversed the ITC of rupees so and so by PRC 03 dated 19/1/2021. Interest and penalty are not paid by the taxpayer. Accordingly, 82 dated 24/1/2022 for an amount of 7,61,000 was issued. In view of the above, investigation against Messrs. Adil Trading Company was initiated by the Officers of Anti-Evasion Wing, Hyderabad GST Commissionerate. Verification, but a lot more because the overall evasion then goes to 7 crores. We check the other. It's only based on one zonal unit, the Kolkata zonal unit. And we looked at Aurangabad, Hyderabad, etc.
So that Sujan Ghosh and Meghna Chaudhary, they were not prosecuted.
They will be prosecuted. That zonal unit has jurisdiction for it. And they are being prosecuted as what?
Yes.
Now, verification of GSTR 2A data, Mrs. Adil Trading Company revealed that during the period of July 2017 to March 2022, they have availed ITC to the tune of rupees 4 crores 47 lakhs 49,324 from the suppliers whose registration was cancelled subsequently, either by way of suo motu cancellation or by suspension. Further, it is also noted that Messrs. Adil Trading Company have availed ITC to the tune of rupees 24,42,953 on the invoices issued by suppliers who have not filed the GSTR PB returns till March 2022. Accordingly, a letter dated 17/8/2022 was addressed to the taxpayer. In response, the taxpayer has submitted their reply dated 29/8/2022, mentioning that the copies of invoices pertaining to the above mentioned transactions will be submitted whenever called for. They have also enclosed a copy of PRC 03 towards the payment made in the year 2019-20 pertaining to the transaction with Messrs. Hindustan Traders and Messrs. Kedar Enterprises. Subsequently, on March 23, it was noted that some of the cancelled firms have again become active and the non-filers have filed their GSTR PB. However, in the above, the cited two instances, the reason for cancellation in respect to about 2 firms which are in the state control cannot be identified from GST by us, and therefore it is proposed that now the proposed SCM is limited to ITC avail from the 6 firms which are reported to be faked by various commissionerates DGGI as detailed below. As regards cancelled units, GSTR PB non-filed cases, it is proposed that these issues can be taken up separately after getting reasons for cancellation of state authorities. Then, in meantime, further information was received from Chief Commissioner Office, TSHC, Hyderabad, by so-and-so, Commissioner Rangareddy, dated 24/1/2023, intimating that Messrs. Apple Trading Company have received goods of taxable value of 28 crores 98 lakhs 16,000, involving ITC of 5 crores 21 lakhs 67,000, so-and-so, from Messrs. Honey Enterprises, RR District, which is reported to have issued fake invoices without supply of any goods. Another letter dated so-and-so, dated 31/10/2022, received from Secunderabad Commissionerate, indicated that one more firm by Messrs. Sukmani Enterprises, which is also a fake unit, had issued fake invoices without supply of any goods to Messrs. Adil Trading Company, wherein ITC involvement was 53 lakhs 41,571. However, verification of GSTR 2A and GSTR 3B for the period of December 22 of Mr. Adil Trading Company revealed that the taxpayer has received and utilized ITC of 5 crores 86 lakhs 22,000, CGST so-and-so and SGST, from Messrs. Sunny Enterprises, and rupees 1 crore 13 lakhs 72 from Messrs. Sukmani Enterprises. Also, another letter so-and-so dated 23/2/2023 received from Aurangabad Commissionerate indicates that one more firm by name Sunshine Enterprises, which is also reported to be a fake unit, has issued fake invoices without supply of goods to Messrs. Adil Company, wherein ITC involvement was 76 lakhs 92,960. Another letter so-and-so coming from Bangalore South, dated 10/1/2023, received from Bangalore South Commissionerate, indicated that one more firm, Messrs. Olax Traders, which is also a fake unit, had issued fake invoices without supply of goods to Messrs. Adil Trading Company, wherein ITC involvement was 86,000. Scanned copy of all the letters referred above are linked and placed on correspondence site. Details of fake firms communicated and respective ITC involvement are given here under a tabular form. Accordingly, to obtain further information in this regard, summons dated so-and-so were again issued to Sri Mohammed Ibrahim. One more summons dated so-and-so issued. The taxpayer has not responded to any of the 3 summons issued. However, on 12/4/2023, one more summons was issued. In view of the above, a revised AE3 for an amount of rupees 7 crores 85 lakhs is proposed to be issued, and accordingly revised final A2 put up for perusal before issue, please. Also, DRC 018 for 7 crores 85 lakhs 36,000 is proposed to be issued, and accordingly draft DRC 018 is put up for approval. Now, I am break here for a moment. This DRC 018 is a notice that can be issued to the petitioner, not in all cases. In some cases where they feel that they want to get some information, so they put him on notice. This DRC 018 has also been given. May I pass on this? Now, here, this is issued under section 74(5). Section again claims he doesn't know where this is, what investigation, how it is, why they're attaching bank account. May I read out? I'm sorting out the copy is grayed out. The file it is counted. Please refer to the above proceedings. Case proceedings, reference so and so. Intimation of liability under section 74(5) of the TSHC Act regarding. Please refer to the above proceedings in this regard. The amount of tax, interest, penalty payable by you under 74(5) of TSHC Act 2017, with reference to the said case as ascertained by the undersigned in terms of available information as given below. Now, with each of the firms, the irregularly availed ITC has been set out in that table, in the third column here. Then the grounds of quantification are given below. Liability is set against which firm? First, the grounds of quantification are given below. Messrs. Adil Trading Company have availed ITC to the tune of rupees 5 crores 86 lakhs 22 so and so, and STST so also basing on invoices issued by non-existing firm, namely Messrs. Sunny Enterprises, without receipt of any goods, services of both during the financial year 2021-22 and 22-23. Messrs. Adil Trading Company have availed ITC to the tune of rupees 1,13,72,136, basing on invoices issued by non-existing firm, namely Messrs. Sukhmani Enterprises, without receipt of any goods, services of both during the financial year 2022-23. Messrs. Adil Trading Company have availed ITC to the tune of rupees 76,992,916 ITST, basing on invoices issued by non-existing firm, namely Messrs. Sunshine Enterprises, without receipt of any goods, services, or both during the financial year 2020-21, 21-22. Messrs. Adil Trading Company have availed ITC to the tune of rupees 7,25,112, basing on ITC invoices issued by non-existing firm, and namely Messrs. Hindustan Traders, without receipt of any goods, services, or both during the financial year 2019-20. Messrs. Adil Trading Company have availed ITC to the tune of rupees 86,940, basing on invoices issued by the non-existing firms, namely Messrs. Olax Traders, without receipt of any goods, services, or both during the financial year 2018-19. Then Messrs. Adil Trading Company have availed ITC to the tune of rupees 36,000 ITST, based on invoices issued by non-existing firm, namely Messrs. Taylor Enterprises, without receipt of any goods, services, or both during the financial year 2019-20. The amount of tax mentioned above is liable to be recovered, along with applicable interest and penalty. Messrs. Adil Trading Company have paid tax amount of rupees 7,61,688 by TRC 03/93/2021. However, they have failed to pay interest and penalty. You have hereby advised to pay the amount of tax as ascertained above, along with amount payable in interest and penalty under Section 745 on or before 4/5/2023, failing which show cause notice will be issued in Section 741 of the TSHC Act 2017, TSHC Act 2017, read with Section 20 of the ITST Act 2017. The amount of tax already paid is proposed to be adjusted in the show cause notice proposed to be issued. In case you wish, this is important, in case you wish to file the submissions against the above ascertainment, the same may be furnished by 4/5/2023, Part B of this form. This was not replied to, Madam President. He doesn't come up with any explanation. He doesn't show his eBay bills. Wait. He was asked to produce all of these. Now, Your Lordship has already seen the Supreme Court judgment, nor it is burden of proof to show that actual receipt of goods is on the SSE claiming input tax credit. That is settlement of the Supreme Court judgment, and again, once again, pass it on to Your Lordship. Now, he has complete information. The file along with several notes of several officers, which eventually is put up in Commissioner based on this evidence. She takes
these were also served upon the petitioners?
No, these are internal notes, not what the requirement is.
No, the correspondence dated 28/4 is addressed to the petitioner.
28, yes, he was supposed to reply to this. He doesn't reply, he doesn't come up with the evidence that we've sought for. Even as on date, he has not replied to this. And this is the basis of the attachment is where subsequently, because he said the attachment order doesn't reveal anything. The attachment order is given to the bank. A copy is given to him. But the record, he is fully aware why is the bank account is being attached. His summons have been issued to him. He has come, he has given his statement, he has signed all the alert notes. In this, the signatures of his also will show that he has seen all the alert notes from the commissionerates, various commissionerates, and asked questions. So he's fully aware, and this letter will clearly show you the quantification is there. So there's enough material record to show the petitioner is fully aware. Now, what is his remedy under Section 83 method once an attachment is made? Now, take Your Lordship's note to Rule 159(5). In fact, I have not today not got it. There were 3 judgments. Power High Court not mentioned. His Lordship also was sitting with Justice Guyan. The 3 cases where there was a matter of 28 crores where the bank account subject to them putting that amount with us. There's another case, which the court said that you first filed your objections to 159(5) and left the case open, and you're free to liberty to challenge the order which is passed under 159(5). And there was another matter as well, where the court dismissed it saying you filed your objections, and thereafter, after the order, what will happen now is they can file an objection under Rule 159(5). Satisfied with that order. That is subject, it's left open to them whether to challenge it or not. But right now, the remedy is available under the Act. They have come to this court without availing that. May I invite your lordships to Rule 159.5. TSHC rule. Lordships have got it.
Yes.
Any? Shall I read out from 1, 2, 3 or straight away go to 5? Because this speaks about the attachment.
Yes.
And 5 speaks about their objection. Shall I read out all? Just come to 5.
Read all.
Very well. Where the commissioner decides to attach any property, including bank account, in accordance with the provisions of section 83, he shall pass an order and form TSHC DRC 22 to that effect, mentioning there the details of the property which is attached. That has been done. 2. The commissioner shall send a copy of the order of attachment in form GST DRC 22 to the concerned revenue authority or transport authority or any such authority to place encumbrance on the said movable or immovable property, which shall be removed only on written instruction from the commissioner to that effect. And a copy of such order shall also be sent to the person whose property is being attached under 83. That has been inserted, my lord, in 2022. And that has been done in this case. I have shown you, lordship. Where the property attached is of a perishable or hazardous nature, if the person whose property is not relevant, 4. Where such person fails to pay the amount referred to in subrule 3 in respect of the said property or perishable or hazardous, that was not relevant. Number 5. Any person whose property is attached may file an objection in form GSTR DRC 22A to the effect that the property attached was or is not liable to the attachment, and the commissioner may, after affording an opportunity of being heard the person filing the objection, release the said property by an order in form GSTR DRC 23. The commissioner may, upon
when does he get this opportunity?
Now he has to file an objection. Attachment took place.
Would it not be served upon him?
Which matter?
The order of attachment.
It has been served. I have shown your lordships.
The first one.
Yes, madam. The order of attachment which was to the bank, that order has also been served to him on the very next day by, yes. The commissioner may, upon being satisfied the property was or is no longer liable for that, to release such property on issuing an order. Now, this is the recourse. He has jumped the gun and come directly here, not under, say, making a lot of submissions, there is nothing on record. There is, where he's fully aware, my lord, that this is not even a matter of a technical nature, etc., like what the courts have said or what the guidelines also say. This is a case of fake invoices, where there is no receipt of goods and the tune goes up to around 7 crores. And the entire file shows that there is a series of notings which has been put up before the commissioner, on the basis of which she makes an opinion that yes, it's a fit case. So it's not that it's without any basis. There are letters received from various commissionerates across India. So she cannot ignore those, not at this stage. In fact, this is a fit case for attachment. The petitioner has not been arrested in this case. Not that in other cases, lordship has seen they've gone one step further and they even arrested non-cooperation, etc. This is only a case of attachment, not and the remedy lies in replying to it. There's 2 judgments I have got. Bombay High Court had relied earlier as well, not before the earlier bench, not this court. But I can't. Later, I will also pass on the judgments of this court. May I pass on? These are just orders, not where similarly it has been challenged on various grounds. This is of the Bombay High Court. The first one is JHM Enterprises. Proceedings against petitioner under section 67 of the Central Goods and Service Tax Act 2017 are pending. During the pendency of such proceedings, the Additional Director General DTTI Nagpur Zonal Unit by an order dated 18 June 2020 recorded in form GSTR DRC 22 has attached a bank account maintained by the petitioner in DBS Bank, Andheri, Mumbai. Such order of attachment is subject matter of challenge to this section. Section 83 of the TSHC Act permits provisional attachment to protect revenue in certain cases. Such power has to be exercised in the manner laid down in Sub-Rule 1 of Rule 159 of Central GST rules. The said rules for short, however, Sub-Rule 5 of Rule 159 provides as follows. I read out this rule. This petition has been presented by the petitioner without taking recourse to Rule 159.5 of the rules. Objection of the maintainability of this petition has been raised by the learned counsel for the respondent by referring to such provision. Mr. Jain, learned counsel for the petitioner, has contended the attachment order passed by the Additional Director General without jurisdiction, since such cash credit account cannot be attached. Reliance is placed by him on division bench decisions of Gujarat High Court, formative text, etc., and Punjab and Haryana High Court in Chandigarh in Bindal Smelting Private Limited versus Additional Director General DGTI. To support such contention, he has accordingly paid for portion of the impugned order. On perusal of the decision in Bindal Smelting Private Limited, it appears the court considered the grievance raised before it only after recourse to Rule 159.5 of the said rules had been taken by the petitioner and an order passed on objection that was raised. This court examined the order passed by the relevant authority and, bearing in mind the facts as well as the legal position, proceeded to pass an appropriate order. It is clear that Rule 5 of Rule 159 of the said rules provides the remedy in a particular order of attachment under Sub-Rule 1 leaves a party subject to tax aggrieved. We are of the opinion that such a remedy as made available by the said rules is not an ineffective remedy, but on the contrary is, if sufficient case is set up, substantial relief can be granted to the objector. It is for the petitioner to satisfy the Additional Director General that, for the reasons urged, the property ought to be released for attachment by making an appropriate order in Form GST DRC 23. The position as to whether the impugned order in fact seeks to protect the interest of the revenue or is otherwise, including the balance in the current account as submitted by the petitioner, would require factual examination and determination. Thus, it is all the more necessary that the petitioner exhausts his remedy provided by Sub-Rule 5 of Rule 159 of the said rules. Should the Additional Director refuse to release the property of attachment, a reasoned order is required to be passed, and such order could be subjected to challenge before the appropriate forum in accordance with law. Since the petitioner has taken recourse to Sub-Rule 5 of Rule 159 said rules, we decline to interfere at this stage. However, we grant the petitioner a week's time to approach Additional Director General. Since the petitioner has not taken recourse, since the petitioner has not taken recourse to Sub-Rule 5 of Rule 159 of the said rules, we decline to interfere at this stage. However, we grant the petitioner a week's time to approach the Additional Director General under the said provision, and if such an approach is made, a reasoned order shall be passed after extending an opportunity of hearing. All contention, the merits and of rival claims are kept open. The writ petition stands disposed of accordingly. Similarly, my lord, another writ petition under Wisemax Enterprises. Relying on this, my lord, they had proceeded. And he gives a short statement of this period. The petitioner, before us, challenging the action taken by respondent under Section 83 of the Maharashtra Goods and Service Tax Act of Attachment Bank Accounts, while order dated 27 July 2022, and for direction to allow operation of bank accounts. Apart from factual aspects raised by the petitioner for contending that the bank account of the petitioner was not liable to be attached, petitioner has raised an issue of jurisdiction of the respondent authorities. According to the petitioner, the respondent being a registered person falling in the jurisdiction of Tamil Nadu GST 2017, the respondent 224 officers appointed under the Maharashtra Goods and Service Tax Act of 2017 will not have jurisdiction over the petitioner. Learned counsel for the petitioner states that this being the issue of jurisdiction, the petitioner is entitled to invoke jurisdiction of the court. What I'm also showing the lordship over here, even a jurisdictional issue, the court did not intervene. Even a jurisdictional issue. In the second case, the lordship has seen that all facts, etc., in the first case relied upon, the court said that even all of those have to be taken by the concerned officer, and those can be raised before the officer. The learned counsel for the respondent has relied upon the decision of division bench of the case of so and so, which I just relied upon, to contend that the petitioner should first take. And para 4, the division bench of this court in JHM Enterprises dealt with the challenge in Section 83. The petitioner had to, and this is the reproduction of that order. And once again, Lord, it passes the same order that he may go before the authority who attached his bank account, file his objections, opportunity may be given to him to be heard. Similarly, Lord, the three others I will pass it on and read the sentence. Lord, this honorable court, Lord, which has said the same thing. Now, the synopsis will give the background, Lord, which I have for 3 pages, because that is we have received letters from all over India. We'll have the synopsis brings out categorically that which all commissioners we have received letters, where is the IPC which he is these firms. Many of these firms now are non-existing. There were no goods. There are no. He was unable to provide his eBay bills, his other evidence to show that he has received of goods. Firms are non-existing. Under those circumstances, it is more than justified not to attach the bank account. They are not pick up. The money only remains in it. At no point it comes to us. Even this attachment is only for a period of 1 year. It's not beyond that. And this recourse is now under section 159.5. Yes. These 5 also alert notices and all from various commissioners which are also in this. Shall I show you, Lordship? The part of the record.
No, the requirement was there were some reasons to be recorded in writing.
The reasons to be recorded in the file.
Yeah, is it there?
These are all the reasons not in the note file. Lordship will see because these are the reasons based on which the commissioner takes a decision. So these are the reasons that are being put forth. These are the files, these are the documents that are put forth before the commissioner before she decides whether it's a fit case or not. So based on these notes, they are the internal notes which she will have access to, and this is all E-file. It cannot be said that she has not seen it, because these notes are all in the E-file. Only after she goes through this, she will put, because the notes are going in sequential order. What you will see 1. Thank you, Lordship. That is not in the act, it is circular.
Circular.
Yes. Circular, I have not filed with this compilation, not with the internal note, but your Lordship, on last occasion, the council had passed on to your Lordship the circular.
Yes.
Lordship, I'll take your Lordship to the circular. Lordship, have the circular.
Yes, 1 second.
The section doesn't say that. By way of the circular. The circular is dated 23rd February 2021. Last one, there is another file. That's the one. I pass on, I have another. Okay. One. Right, just doing this from the file. I'm sorry, the other one, second copy is not pinned together. Your apologies for passing like that. Yes, you take this out from the file. Actually, with your file, Lordship record though, because last occasion it was passed on to your Lordship and relied upon. That's the reason I did not pass it on again. May I? This starts at 3.1.2. Yes, section line of 3.1.2. Refusal of the above position of law suggests that the following grounds must exist for resorting to provisional attachment for property under the provisions of 83 of the Act. There must be pendency of proceedings against taxable person under sections mentioned in section 83. 83 mentions 3 chapters, which is section 67 to 83 is there, and again 73, 74. I've already shown you lordship summons, etc. have been issued, so there is no doubt on that. The commissioner must have formed an opinion that provisional attachment of the property belonging to taxable person is necessary for the purpose of protective interest of the government revenue. The forming of the opinion under section 83 is important. The commissioner must exercise due diligence and duly consider as well as carefully examine all the facts of the case, including the nature of offence, amount of revenue involved, established nature of business, and extent of investment in capital assets, and reasons to believe that the taxable person against whom the proceedings referred to in section 83 are pending may dispose of or remove the property if not attached provisionally. The basis on which the commissioner has formed an opinion should be duly recorded on file. It is reiterated that the power of provisional attachment must not be exercised in a routine mechanical manner, and careful examination of all the facts of the case is important to determine the cases is fit for exercising the power under section 83. The collective evidence based on the proceedings inquiry conducted in the case must indicate that prima facie a case has been made out against the taxpayer before going ahead with the provisional attachment. The remedy of attaching being by its very nature extraordinary has to be resorted to with utmost circumspection and with maximum care and caution. Then procedure for provisional attachment, that may not be relevant. Then I come to 3.3. The procedures also relied upon the petition of if your lordship. So please, I'll take your lordship to it again.
3.2 is also relevant.
I'll read 3.2 as well.
3.2.1.
In case the commissioner forms an opinion, may I read?
Yes.
In case the commissioner forms an opinion to attach the property, including bank account of the taxable person in terms of section 83, it should duly be recorded on the file, the basis on which the which he forms such an opinion. He should thereafter pass an order in form GST DRC 22, which proper document identification number mentioning the details of the property being attached. 3.2.2. Copy of the order of attachment.
Where is compliance of 3.1?
3.1, not I've shown now. I'll take your options again. Now, there's subsequent note. It may seem that first there is on top, there are no page numbers in the note 10 is the next note. Page note 2, thereafter there is note 10. Now these are various officers which are making their comments and investigating officers and putting it on the file. Thereafter, your lordship will see there is note 15, 16. Note 16 again gives notes about may please be seen. And then again the investigation. Then your lordship may come to note 17. It is in the just below the middle one. Notes above may kindly be seen. That similarly, the note that I read out initially, those were similar notes by various investigating officers. Now, as undersigned was duly authorized by the commissioner, an amount of ITC balance available rupees 11,52,507 has been blocked. Further, taxpayers Messrs. Adil Trading is active and gave statement he did not admit for receipt of fake invoices. The taxpayer appeared that he availed ITC to the tune of 7.85 crores. In view of the above, it is proposed to provisionally attach the bank account of the taxpayer under section 83 in the interest of safeguarding revenue with discretion of the commissioner. Please elaborate the reasons evidencing fraudulent availment of ITC so as to enable the principal commissioner to take a decision with related to provisional attachment of bank accounts. Then, my lord, in the note 19, my lord, they elaborate the reasons. Lordship has seen note 19.
Yes.
There are the reasons again that has been put. Noting may please be seen. And there are again reasons evidencing fraudulent availment of ITC. When information was received from various commissionerates mentioning that the taxpayer has availed ITC from firms which were found to be fake, details of ITC availed and issuing firms given below. The table has been put up in respect to the above said firms. Panchanamas were drawn by the respective commissionerates, department wings in all the above cases, except in case of Bangalore commissionerate. Cases of Panchanamas are linked to the firm suppliers listed above. As the originating firm itself is stated to be non-existing, there is no chance of receiving any goods from them. Then analysis of the e-way movement pertaining to this is all put before the concerned officer. Then in the next noting sheet at note 22. At note 24, 23, the notes are then short notes is 22, 20, 23, and then at 24, that's 23. Though it looks like 24 is the next note, it's 23. As proposed in note 22. 22 is both the above bank accounts may be attached, please. 23 is the commissioner after producing all of these, which has been put the evidence before.
Yes.
However, this is the internal record which I produced. It's not practice to normally do this. Not actually put it before your lordship to show that there is a lot of evidence on record for attaching the bank account. And the commissioner has in fact. No, it's 23 now because 24 is of the next person. There is like a margin under which they fit. It's 23. Even I thought it's 24. Note 24 is of the additional commissioner. Note 23 is of the principal commissioner. As proposed in note 22. 22 is above note. Both the above bank accounts may be attached, please. This is of the deputy commissioner. So these notes, based on all of these, she looks at all of these and then deputy commissioner also reads it and then she goes through this evidence and says, yes, as proposed by the deputy commissioner, please attach the bank accounts.
Yes. That's all. Yeah. Yes, Mr. Council, you want to add something?
My friend has given note this saying this bank attachment, provisional attachment was sent on mail. I will find out only whether it was sent on mail. But section 83 and 259 a copy has to be sent to the dealer. Normal practice, they will be sending it by registered post where an acknowledgement is available. And we should also upload on the web portal. We have ascertained that it is not even on the web portal. What prevented them to upload on the web portal or sending by registered post? Not my friend has explained. Then what my friend is now saying
is you are not adopting. This ground is being invariably be taken. That yes, it's not being sent by.
Actually, the ground is not available. 169 if I may invite a lordship. Section 159 of TSHC. Those were cases after OIO were passed in London, but strictly speaking about 169. Mention service of notice in certain circumstances.
$169.
Any decision, order, summons, notice, or other communication under this act or rules made thereunder shall be served by one of the following methods, namely, I come under C method. By sending a communication through his email address provided at the time of registration or as amended from time to time. Then D is by making available in the common portals, etc. what the learned senior counsel is saying. But C says, I have shown his registered email address. I have shown the registration certificate, not showing his email address at the start of my argument. That is his email address. And it is sent to that email address. And 169C says that that is a proper mode of service.
Yes.
But in the GRC 01, A, page 67 of my retail papers, I myself have filed page 67. This is the GRC 01A, but which my friend is referring. Now kindly come to page 68, bottom of 3. 8, bottom of 3. You are hereby advised to pay the amount of tax as a certain above, along with the amount of applicable interest and penalty under section 24(5) on or before 4/5/23, failing which a show cause notice will be issued under section 741 of the CGST Act, read with section 20 of the IGST Act. So, Lord, this is an ascertainment by the department basing on some information without any show cause notice to me. I need not immediately pay. If I don't pay, then what follows is they have issued the show cause notice, publishing entire information, and I have an opportunity to revert and place my evidence. Then adjudication order will be passed in original. That is the procedure contemplated under that. Now, kindly see note section 83 contemplates, which was been considered by various high courts, including our high court also. And I explained that recording of reasons by the commissioner, because the under section 83 officer is only the commissioner, not the additional commissioner, not the assistant commissioner, not the joint commissioner. For the internal purpose, they may be relying on some officers for assisting the commissioner. But commissioner is the person who has to take the call on it and record the results. Now kindly see, now my friend has given a bunch of papers. Kindly come to note number 30. They are not numbered none. That is the nine. Page 30. Note 30. One page before candidate. Website under section 83 is there on the top. Accordingly, to draft DRC 22 are put up for perusal and approval. Please, this is the draft. Everywhere they are saying no table will kindly be seen. Keep efforts to avail the place so and so, available additional balance so and so. Further, in the interest of the safeguarding government revenue, municipal commission may take attention under section 83, put up for perusal and other space. Nowhere I find that reasons were recorded. Basically, this is what my friend was reading earlier notes were all the information furnished to the commissioner. Commission has to form an opinion. In these are the reasons for which I am blocking the account. I have decided to block the account in the interest of the revenue. That's what one of the honorable courts have explained, section 83. And the circular given by the commission, the CBD. So my submission is section 83 requirement was not satisfied. Then my friend is saying they are relying on some information on success by the various dealers in Calcutta, so many states. So in areas of cruise tax. If my friend's argument is to be accepted, the department statement has to be accepted. I have only purchased the invoice. I have not purchased any goods. Then where is the question of output liability on me? Without purchase, how can I sell? So there is no tax liability on me then. For output liability, only I am adjusting my input. If there is no output liability, where is the question of my input? So they are admitting my output liability, accepting my returns, but they are not willing to accept my IDs. And they are saying that since 2017, department itself has acquired, granted registration after certification and inspection by the officer concerned to the address. Then purchase from those dealers, verifying the web portal whether the GST registration is alive or not. Having the consideration paid through online. And it is not a small place, not where just like hiding this product, I can transact the move the goods or do some transaction, not fake transaction. Without movement of goods, so many checkposts could be there. So many toll gates are there. Now they are because some states have abolished the checkpost. They are relying on the toll gates information. These are the information which I am entitled for it. And I can certainly cross-examine them whether what basis now my notes was after GST, though it's an indirect tax earlier VAT and APGST. After GST, they have become like police officers. Not all the statements are being recorded. Supreme Court has also noticed how they are recording the statement. So simply because they recorded some statement from the other state dealer, it can't be just liability can't be passed on to me. I already read 2 judgments, and I have 2 more judgments. The other I have given Madras High Court judgment. Madras High Court judgment. No, I have given only this.
APN Travels.
Yes.
That we have. The other one is not there.
Gujarat High Court judgment I have given my notes of seen already. One more judgment of the Gujarat High Court. In pro con what I given earlier. In pro con judgment. In pro con. Gujarat High Court. First judgment I reached.
We have got Gujarat, we have got one.
Yes,
There is one more.
Remain on that.
One more.
Now I passed on 2 more. Another judgment in Pranit M. Desai versus Lordus. Additional director.
Yes. We read the Chennai one first. We read the Madras High Court first.
Yes. Look at page number 4, we got paragraph 6.
Paragraph
6, not paragraph 4. The simple language used in section 83 of the TSHC Act may suggest that the commissioner is of an opinion that for the purpose of protecting the interest of the government revenue, he can invoke section 83 of the TSHC Act and to attach the property provisionally including the bank accounts. However, the said content of section 83 of the GST Act was interpreted by the Honorable Supreme Court in Radhakrishna's case, where the following mandatory guidance has been given. I would annexed the judgment of the Honorable Supreme Court in the material papers of the petition. They just extracted the gist of the judgment. Then and we come to para 29, not a page 6. We apply para 29, page 6. If we apply the set for 4 clauses in the facts, number so and so the case, certainly this court without hesitation can come to the conclusion that set criterion fixed by the Honorable Supreme Court in the other case has not been met in the present case by the Commissioner who passed the order under Section 83 Act. The Commissioner in the impugned order under Section 83 merely says, in order to protect the interest of the revenue and in exercise of the powers conferred under Section 83 of the TSHC Act, I so and so additional Secretary Commission says that hereby provisionally attach the aforesaid account. Same language has been adopted not in the impugned order, kindly see. Same as it is, but it is a pro forma which they are following. 31. On what basis the Commission has decided to invoke Section 80 to go for the provisional attachment before which whether the Commission has formed an opinion to do so, before forming such opinion, what are all the tangible material available before him or placed before him, so as to enable him to form such opinion shall all these aspects have not been even indicated in the order of provisional attachment. This kind of exercise of the power under Section 83, which in the words of the Honorable Supreme Court, and cannot be approved, does not meet the requirement of fair play and strict adherence. Now, the provisions of the Act and the report of the report in the judgment cited supra rather than of case. Then kindly come to the next page, where they are not structured from the judgment. Para 16 note is there. Though an argument was advanced, at page number 7, though an argument was advanced by the learned standing on the requiring for the revenue that based on the tangible material which are available with the revenue, they can very well sustain the order of attachment. This court, however, feels that the present order shall not stand in the legal scrutiny and does not reveal any such tangible material. Therefore, if these orders are satisfied, does not procure the revenue to proceed further by once again invoking 83 of the Act, and it has been indicated by the 42 also see Meenakshi Industries case which they have referred to.
Yes.
Then we go to the other judgment which is now a passed on road. On name, this guy was a personal director. At page number 27, blood para 27.
Which one?
But this is not the below the judgment in Granite Lane case files. Just now I passed on.
Yes, yes. Paragraph?
27, not at page 27. That's why. This court had occasion to consider Section 83 of the State Act, GST Act, at the length in the case of Developers Industries versus Union of India, so decided on the 28th August 19. The court of exhaustive discussions on subject summarized its final conclusion as that. Our final conclusion is summarized that the order of provisional attachment before the assessment order is made may be justified in the assessing authority or any other authority in court in line with the opinion that it is necessary to protect the interest of the revenue. However, the subject to satisfaction should be based on some credible material or information and also should be supported by superseding fact. It is not any and every material household vague and indefinite or distinct remote or far-fetching which would warrant the formation of links. Then they have extracted the earlier judgment from observations. Then para 28 and para 28 note. Section 83 of the GST Act empowers the assessing authority to make a provisional attachment of any property of the assessee during the pendency of any proceeding for the assessment or reassessment of any turnover, even though there is no demand outstanding against the assessee. If he is of the opinion that it is necessary to do so,
protect the interest of the revenue. The provision has been made, in our opinion, in order to protect the interest of the revenue in cases where the raising of demand is likely to take time because of the investigation, and there is a apprehension that the SSC may default the ultimate collection of the demand. In other words, Section 83 gives a power to the SSS during the pendency of any proceeding for the assessment and reassessment, so that the SSC may not better away of the resources out of the reach of Commerce Tax Department when the assessment or reassessment is completed. The expression for the purpose of protecting the interest of revenue occurring in Section 83 of the Act is very wide in its meaning. Further, the orders of provisional attachment must be in writing. There must be some material of record to indicate that the assessment authority had an opinion on the basis thereof that it was necessary to detach the property in order to protect the interest of the revenue. The provisional attachment provided under 83 is more like an attachment for judgment under the Code of Civil Procedure. It is a liberty, liability, and the property. However, power takes is very drastic for achieving power. That power has to be used sparingly and only and subject to very grounds and to ensure that this power is not misused. No safeguards have been provided in this section. Next, 83. One thing is clear that power should be exercised by the authority only if there is a reasonable apprehension that the SSC may default the ultimate collection of the demand that is likely to be raised. On completion of the assessment, it should therefore be exercised with extreme care and circumstances. It should not be exercised unless there is sufficient material record to display satisfaction that the city is about to dispose of the whole or any part of its property with a view to withdraw the ultimate collection of the demand. Also, attachment should be made to the properties and to the extent it is required to achieve the above object. It should either be used as a tool or harass the SSC, not to be used in a manner which may be a reversible detrimental effect on the business of the SSC. Ultimately, other certified from the para 13 results applications assumed the way above. And my friend was saying, I am having the entire information with me, so I can file objection. But the Honorable High Court of Andhra Pradesh, but I filed the copy along with the requisition itself, rejected that condition. At page number 56 of the material papers, the Lordship will elaborate order and consider the judgment of the Honorable Supreme Court and various High Courts. Ultimately, but para 17 onwards at page 64. So para 17 a perusal of the impugned orders para 17 at page 64. A perusal of the impugned orders of provisional attachment shows that the fourth respondent hearing stated in the said order that as per the information available with the department, in order to protect the interest of the government revenue in exercise the powers conferred under 83 of the Act, the account is provisionally attached. In this context, it may be appropriate to refer to the provisions of Rule 159, the Sales Tax Act, Sales Tax Act rules, according to Sub-Rule 5 of Rule 159 of the rules. The SSC may within 7 days of the attachment and Rule 1 file an objection to the effect that the property attached was or is not liable to attachment before the commissioner or the commission may, after putting an property being covered, to the person filing the objection, release the said property by an order in Form GST TS 23. Admittedly, except saying that the orders of provisional fund passed in order to protect the interest of the government revenue, no other reason are assigned by the both respondent in the impugned order for provisional attachment. When Sub-Rule 5 of Rule 159 rules specifically provides for filing objection in orders of provisional attachment. The condition of the reasons for order of provisional attachment was recorded in note 5, and that there is no need to accept the same or state the same in the provisional order of attachment. This considered opinion report cannot stand for judicial scrutiny. The Honorable Supreme Court in the above report judgment also categorically ruled that the formation of the opinion on the basis of tangible material which indicates the necessity to order provisional attachment to protect the interest of government revenue is mandatory. Unless reasons are recorded, broadly the SSC cannot be expected to raise any objection under the provisions of Rules of Rule 5 of the rules. The Honorable Supreme Court in the above report judgment held that excess of ungated discretion under Section 80 of the Act would not be permissible as to leave citizens and their legitimate business activities to the period of having regard to the language of employed by the legislation in Section 80 of the Act and Rule 159 by the rules and the judgments referred in the Supra. This court of the opinion that the court respondent failed to adhere to the mandatory requirement of formation of the opinion. There also the submission of the learned counsel of the witness that person equals addressing the service provisions of Section 67 of the Act. The respondent authorities concluded the inspection search and seizure. It is also submitted by the learned counsel that pursuant to the summons issued under Section 70 of the Act, the director, the employees appeared before the complaint authority and their statements were also recorded and the documents were also seized. It's further submitted in view of the same. It cannot be said the proceeding under Section 67 of the Act are pending. In order to show that the respondents have concluded proceeding under Section 60 of the Act, a copy of the order of seizure by GST INS 02 under the 139(2) the rules is filed as material paper. On the other hand, it is submitted with the government paper that the provisional orders of attachment were communicated to the sister and the proceedings under Section 67 are still incomplete and are pending. In view of the above reasons, having regard to the submissions of the learned petitioner and the judgments referred to above, this court has opinion that it has made out prima facie case for grant of intermediate. For the opposite reason, there shall be an interim suspension and provisional attachment.
That repetition is still pending.
It is pending, Lord. Now, in fact, after 1 year, it automatically it goes because not under the Section 83 itself. Lord, once the attachment is more than 1 year, Lord, it automatically lapses.
Yes.
Judgment of the Honorable High Court, Lord. There are 5 that at page 3, Lord. We are afraid we cannot accept such contagion on behalf of the respondents. Attachment of bank a provisional measure is a serious intrusion into the private affairs of the citizen. Being a drastic measure, there must be overwhelming reasons to justify such an action. As already mentioned above, it is not a case of complete evasion of tax by the petitioner. Petition has on its own date so and so, which has been acknowledged by the respondent. According to the respondent, there is a short payment of the tax. At this stage, we may mention that the quantum of mentioned by the respondent is only a provisional figure, even before issuance of any show-cause notice, not to speak of any adjudication order. In such a case, attaching bank account of the petition is not justified and would be wholly without jurisdiction. Continuation thereof would be highly oppressive and violative of Article 14 and 21. My submission is not, my friend is producing a lot of record. I have a right under the Act to file my objections if they give the show cause notice. They only said, somebody said, I sold only fake invoices. They should furnish that information. I have a right under the Act, even cross-examining on what basis they gave a statement, and I can produce my entire evidence, including invoices, wages, payment particulars, everything I can produce before the adjudicating authority. He has to ascertain and then pass an order.
Are they part of the writ petition? These document invoices,
No, they are thousands, so many invoices. They are all not, they are having all the documents with return. I am filing returns. It's not a case that I am not filing returns. My only submission is that identical issue has been considered under the APJ Act, where their department is saying it's a separate transaction, they are only selling not invoices. If really the invoice is sold, then where is the liability next to the next dealer? But then only one say, if there is no goods movement, then where is the sale on by me and where is my output liability? Why should I adjust the input? If they are denying my input, then there is no output liability at all. According to them, I have not purchased any goods, only invoice I purchased. If I invoice I purchase, why should I disclose my turnover and pay more on my sales more than the tax which they have reported and claiming input? And 2017 onwards, I am doing business. Those errors also doing from 2017 after the GST introduced. In 2022 or 23, they made an inspection and saying that he was not available on that day. They cancelled the registration, and the consequences are denying my import, cancel my. They can do everything, but there should be some law. But 83, that's the reason for various high courts. I brought only few judgments. All the high courts not unanimously come to the conclusion. 83 is a drastic power, and very child which they have produced. I show nowhere the commission has recorded. At least they were recorded saying that this is the material placed before me. So considering these material, I have considered opinion that unless the bank is a provisional tax, there is a likelihood of evading the tax, and it will be difficult for the department to recover the money tomorrow. And there are the cases where if even such circumstances, court said that first we must see that if any immovable property is there, you do that, so that their day-to-day business activity will not suffer. No exercise is done in that angle. Nothing. And that Gujarat case also same thing. Same scrap dealer. Same saying that fake invoices. Reports say that fake invoice was sold. Same everywhere.
Yes.
My submission is not. They have the power under the act. They want get them to by recording the reason that what Kanpur High Court has also given, saying that they are not powerless. They can again issue because there are so many more than once they can issue. There is no bar. Without saying anything in the provisional attachment, what is the objection they can expect?
At this point in time, the two judgments that the Honorable Senior has right. One is of this court, which troubles me because that is the court which will be bound by emotion. That judgment, I guess, since it's the last judgment that has been given, judgment is slightly different. This is a case Lordship has reproduced. In this case, they are going to the Supreme Court. Because an opinion has been sought from me also on this matter. There is a ground here that there is no DIN number. There is a circular that says if any document without a DIN number is not considered to be a document at all, and therefore that attachment order did not have a DIN number. And that was the primary ground which is reproduced in this order. And it has been said there was not, because 159.5 was taken. But the court said that no, forget 159.5, the document attaching itself has no sanctity because it does not have a document identification number, which as per the circular is required. Secondly, there is another order of this court I managed to lay my hands on. In fact, there's another case also I'm not able to lay my hands. This is in fact the mega engineering law where senior counsel very clearly is hearing on. The accounts were continue to be attached. Or so and so, learned senior counsel for the petitioner, Mr. Gadi Praveen Kumar, so and so. And the petitioner has agreed, amongst others, attachment of his bank account. And bank account being account so and so 1, 2, 3. Hyderabad by respondent under 83 of the Central Goods and Service Tax. Though notice in this case was issued, respondents have not filed counter level. Let counter level 5 be filed the response on next day. In the meanwhile, it is open to the petitioner to file objection under 159 of Central Goods and Service Tax Act 2017. If such an objection is filed within 7 days from today, respondent number 4 shall pass appropriate orders thereon under subgroup 5 of 159 without a period of 2 weeks. from date of receipt of such objection after giving an opportunity of personal hearing to the petitioner. Post on 90, the attachment still is holds on date. In fact, the matter came up even yesterday before your lordship. Now, the other judgment of the AP High Court. Now, it's one the only other Telangana High Court judgment that was not on the ground that the 159.5 is not available. It was that there is no DIN number, fundamentally different. Then in this judgment of the AP High Court, and that's a pending case. Nevertheless, your lordship will see at page 64 of that order. Paragraph 17. In result, with this application stands partly allowed. The relief with regard to the order in form GST DRC 018 is not granted. In that case, there was no form DRC 018. Therefore, the petitioner had absolutely no information. Here I have shown your lordship under 74.5. A DRC 01A has been given to him prior to the attachment itself. So he was given with quantification, etc. And the other judgments have not looked into 159.5, which he has liked. The AP High Court has, but there was no GST DRC 018. Fundamental difference in this case as well. He has that information.
Great respect. That is an additional ground I have taken. The ground is 83 requires not appearance to be found. It is not there. That their lordships have relied on the Supreme Court judgment and the Gujarat High Court judgment. My friend is saying, showing the first judgment where I don't know whether the 83 was challenged and the original letter was challenged on the grounds of there are no reasons or not. They only spot time. And what this court has not given the opportunity to the RCC to file an objection. My case is what is the information you are furnishing the original letter to file my objection. That's what every court has found. Yes, one name, but I can't file any objection to this. He should all furnish every document. This is only he is only saying pay this amount. You should show cause notice. It's a warning not before doing that. Either I should issue a show cause notice for the proposing assessment where minority interest all will come. Otherwise, you come and pay it on your own. For this, I can't file any objection. And usual letter should record reasons.
Reasons to be recorded in the file, not in the order. And one secondly, the judgment, which is the Supreme Court judgment, based on it, the circular has been released now. So it is not, the judgment looks into that. The circular also covers everything. There are two judgments. Another one, rather, Sham also, which says after the show cause notice has been issued, the attachment goes, etc. That has also been overcome by the Act because it now says pending any the initiation under any proceedings.
Yes. Should pass orders.
I'll only pass it. I will not read out the paragraph. This is the burden of proof. They have categorically said in a synopsis person he is not given e-way bill, Deepak. No, Deepak is exemption. This is burden of proof. Squarely.
It did not please prove that state not yet. The issue show cause notice in support of my claim I have produced. But there is no facility to upload my invoices on the web portal. I can only upload my return and payment particulars. And that is at a stage where the order is passed, the show cause notice is issued, and the opportunity to produce everything. Even only the investigation stage, they can't determine saying that I should pay. There is a circular of the friend also knows. There is a circular of the department saying that if it is a circular transaction of fake transaction, the person who is claiming ITC, no tax will be demanded. They get best levy penalty. That is circular. Is aware of it.
No, in fact, now the senior is making complete different submission. This judgment is not his case. 20 falls in this because it is for him to prove that the goods actually moved from the supplier to him. This is what the judgment says, and the burden of proof, which is required, burden of proof is on the SEC. In this case, what the Supreme Court said, it is anyone claiming input tax credit. It is for them to prove, and there's the allegation is that there is no supply of goods. It is for the recipient to show by way of e-way bills, etc., that he has actually received the goods. And even in the GST Act, the Sales Tax Act, the GST Act section 155, burden of proof is of the SEC. Similar to this judgment, the ratio laid down in this case squarely applies to the petitioner.
Notice say that Stage has not reached. Stage has not reached. When you should propel, no time to reach that. And when it's not bringing you consider before. Much of less of patient getting to apply. The judgment is not Supreme Court also admits in the middle bit. TSHC case also. Is there in the grid fund itself? 637.
It's there on record.
Yes, much.
Yes, now you'll have to start all the way.
I will to start again.
Especially on lighter vein, government have got and these lordships have got the other.
And also in the letter, I was told that traditionally in this court, after Diwali, again, there may be some changes in the custom.
So informed by council and tried to inform me also that some internal rumor mills, nothing else.
So of course, it's a rumor, but I'll start, then I'll have to again start on again. So
You always know far better than us.
At times it's the bar which knows more.
knows more.
Most of the time.
That's true. That's true. I was suggesting 21st if your lordships give me at the top of the board or at 12 o'clock, I'll take 1.5 hours.
Not top of the board, please.
Very well, at 12 o'clock.
Do second up only, because otherwise the fresh matters get stuck up.
That's true. That's why I suggested 12. But if your lordship says 2:30, I'll then finish it on that day. What I'll do is I'll give a written note. So I will not take your lordships through those 500-page charge sheets. Show cause. Sorry, show cause. I'll give a note pointing out the relevant paras, and then I'll just make my argument. Otherwise, this is going to be never ending. So then we'll also see whether the bar knows better or.
Yes, that week also we have fixed so many matters. 21, 22, 23.
This is one of the other matters.
I'll start 21 to 30. I'll let's say if I give for 1 hour. So again maybe 20 after 3-4 days again another 1 hour and then I'll finish.
It will take a little longer. Lordship may have it at 2:30 to 4:30.
Maybe by 2 hours you will be able to conclude.
I'll give a note. I will not go through the entire. If not 21st, then
How about 22nd?
22nd,
There is some vast matter which we have given already.
22nd. But could it be then 30th?
30th is a holiday. Going to be declared a holiday. It's an election day.
Oh, excuse me. Let it be 21st, I'll see how much I can do.
Since we're not the senior is here, there's one submission I wanted to make, but the senior went through even if my counter is the court when the matter came up was confined the issue to this small point whether or not a pre-notice show should have been issued. So I even filed my counter to the affidavit categorically saying that I'm only addressing this point since the court had confined it to that point. In fact, the court initially did not even ask me to file an affidavit, only an instruction that I'm going to decide whether or not if a pre-notice, a pre-show cause notice is to be issued, then we will close it on that. If not issued only on that aspect because they had raised it, the senior was not appearing there. There was another counsel there. So the record will reveal it. Then I was to file an affidavit on that aspect. And I filed an affidavit only on that. Now when the contents of the show cause notice are being gone into, which is then traveling beyond. I have not filed a detailed counter as to going into all of that because the court had confined the issue only to that.
So at that point of time, the court thought that it could be disposed of on that point. But my lord, if he wants to file more comprehensive affidavit, let him do that.
What I'm saying is just not the court heard it on the day 1 and day 2 and then said I'm going to only confine the issue to this on this aspect. So that is how the matter then moved forward. So that is why even it was only coming on this aspect. And my counter, the first paragraph, I categorically said so. That it's only on this aspect and because the court wanted clarification on this aspect. I've not gone into, I've given a synopsis of brief. So the court.
Now, so far as the contents of the show cause notice, his major ground is only that the reading of the contents of the show cause notice would lead to a conclusion that the authorities are predetermined.
Yes.
That is the only thing.
And
that's not by my arguments.
It has to be only looked at the show cause notice itself has to be seen. Nothing else has to be seen.
Even the docket order will reveal that.
No, I'm not disputing what you're saying.
Anyway, I'll leave it to your lordship.
If you want to file, you can file, but according to me, it may not be required.
No need prolong, already this matter, some way or the other is unable to.
I will confine myself only to the show cause notice, and therefore you have to only refer to that.
Docket order dated 24/3.
9-3.
Like I was saying, Lordship was transferred, he will be privy to that hearing.
Yes. So you take a try on 21st?
Yes, 21st.
Request on the joint request made by the council. Hearing on 21st of November. 2:30. 2:30.
I thought we had that earlier matter.
It was called in one.
Matter of project was fixed for 2:30.
No, in fact, initially we thought that since it was heard by the other bench, why not let it go to for a date when that bench would be constituted, but then that will be a difficult.
Let's see also 21st.
Yes, yes.
And if you
Lordship is also in case not heard the matter starting, so it's as good as the same bench. It's a lot of things.
actually, your Lordship may give it part that we have not notification.
No, we have not started. We are going to start it out together again. That is so interesting.
46. If you, what does it call?
I filed the permission petition and a major declaration petition of the third petitioner because it became a major, your lordship, by finding that 10 class memo.
Okay.
Third petitioner was minor, your lordship, but he became major, your lordship, by filing major declaration petition and also filed the.
That is IA 1/2, 1/23.
Yes, Lord.
That is for declaring the.
Yes, Lord. Third petitioner as major. And after class SSD memo was filed, your lordship, in proof of her becoming major. Other petitioner is permission petition, your lordship, her share of amount. Your lordship, other petitioners 50% they already withdrawn. This petition amount was under the fixed deposit. So now she got a medical seat, your lordship, recently. She required the amount, your lordship, and I believe it permitted, and first week of December, your lordship may force the matter finally. I will.
Why not today?
No, your lordship, not. File is with my junior, your lordship. And meanwhile, your lordship, that.
What do you say on this?
Yeah.
What do you say on these two IAs?
That is the permission is given to majors. Major declaration, I have no knowledge. Withdrawal because others have received. Withdrawal is.
So there seems to be a genuine cause also. If she has got a seat in a middle college, obviously that would incur some.
As minutes are concerned, the check given to our premium is returned. So the insurance company is disputing their liability, they have cancelled the policy.
Interim relief was already there, your lordship. This petitioner can be granted the same relief, your lordship. First week I will be able to produce my argument.
Take one, which is an application. By Monday.
Applies, deeply applies.
When do we fix it?
Well, lordship may post first week of the December.
Let the appeal be listed for hearing on the 14th of December.
Apply.
Rest we'll take up.